stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, 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 everybody. Happy Wednesday. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. We are on part 3 of the post-conviction relief hearing of Todd Mullis, who was convicted of killing his wife back in 2019. He had filed a couple of appeals that were denied, one in 2019, one in 2020, and then in 2025, he was given his post-conviction relief hearing. He was granted a hearing, and we are on part 3. So today, just a heads up to you guys, today is a shorter day for me. It'll probably be I probably need to get off here at about 12:15 my time. So it'll probably be about a 4-hour live. We'll be splitting it up till, part 4 tomorrow. So let me say hi to you guys. Hi, Delana. Hi, Dina. Hi, Rexy. Hi, Scales. Post-punk mama's just stopping in. Got to go to the doctor. What's up, Ems? Oh, gosh, don't even. I got so many messages about that. It's so crazy. So crazy. Hi, Ariel. What's up, Rexy? Rexy. Hi, Indiana girl. What's up, Kathy Spank? Kathy Spank Bank. Hi, CH. So, yeah, Indiana girl, you know what? I have no idea. That was actually crazy. I don't know how they got the text messages between the pathologist and the sheriff now, because he's now the sheriff of Delaware County. And they're not from around the time of the crime. Hey, AG, hi, Laura. They're from the post-conviction relief time frame. They're from now. Well, not now, but like last year now. They're not from around the crime or any, I don't know. That's crazy. Like, these investigators better start paying attention, or, law enforcement better start paying attention. I would love for somebody to get their hands on a fucking Holman Liggett Lesenby group chat. Like, could you imagine? Because this is not the first time we're hearing now of attorneys and the courts getting a hold of private text messages. Maybe they were on work phones. That's the only thing I could come up with. I honestly have no idea. So I had filed, which, speaking of, let me actually double check. I filed a ton of Foya requests in this case. I have only received one response. Well, technically I received 2 responses. One from them, one from one of the places saying, "Hey, we don't do that here." Well, like, we don't have access to the things you're asking for. You need to contact this person. So I filed a whole bunch of FOIA requests, and I've only received back a PDF file of the 2019 appeal, which is just essentially all the documents from the docket, and then a file with all the documents and filings from the 2020 appeal. So the 2019 appeal was an interlocutory appeal, and it's only like 37 pages, so it was kind of easy just to skim, and one of them was actually the transcript. The 2020 appeal, however, is about almost 600 pages long, and I was trying to skim it to see like if I could just like any new info popped out at me, but I haven't really I haven't really got to dive into that one yet. So I don't know if there's info in there that I'm like, you know, about the case that I just have no idea. And so I'm hoping I'll get some more responses here there by the end of the week for the other ones. Because right now it's only 2 document dumps, really. Hey, just Jen. Hey, Mav. Let me see. You guys are silly. Indiana Girl says, at the very top, I had 2 things about what has stood out in this trial so far to me. The state using the 911 shit and now trying to keep her out of the shed. Yeah, can't have her in the shed when you have, or, you know, I guess the whole thing is to show that it might not be in the shed because now you have the the biomedical engineers are saying that it's not possible, which we haven't really got to yet, but they already know it's coming because they know what the whole basis for this post-conviction relief hearing is. Hey, Chris. Hey, Ellie. So, like I said, I haven't really got to go through all of that yet. I kind of just took a peek, and there wasn't anything that like popped out, but it did seem like there'd probably be some good info in there, just on, you know, maybe stuff that doesn't make it to trial. So, and one of the reasons I was asking for this Foya stuff was because when I was on Fish's channel with Paul had mentioned that for the post-conviction relief hearing, that there are, and I don't remember the number he said, I'm going to say 20, but I don't remember if it was 20, could have been 10, could have been 15, depositions that the witnesses didn't actually testify in this post-conviction relief hearing, that their depositions / affidavits, I don't know if they were filing affidavits or if they were actually deposed, were just submitted to the judge. He said 20, okay. Were just submitted to the judge for review, so we never got to actually hear their testimony. So I'm trying to get that, and I'm also trying to get a clear version of the interviews with Todd, and I want to see what they have with like Jerry and whatnot. But the 911 call, okay, hold on. Both Hammers and Nye said the shed doesn't matter because the defense is asking now because they are on to the state. Right. But the 911 was not evidence like he said. That was a statement by the prosecutor, and we all know that's not evidence. Right. Well, she also told the jury that, so that's how they got away. That's how she got away with it. Told them to make up their own mind. Just Jen says, I wasn't able to watch the trial with you. Did the defense in the original trial not use Hammers and the bioengineer? No, no, Just Jen. Unfortunately, the defense attorney in the trial used nobody. There were 3 defense witnesses, one of them being Todd Mullis himself, and that was it. And none of them were experts. One was his brother, and the other one was, oh shit, now I can't even remember who the other one was. Why the hell can I remember who the third one was? One was Mike Mullis. One was Todd Mullis. Was it Krogman? Yeah. It was Krogman. Okay. Yeah. I was like, wait a minute. Why can I not think of who that is? Yeah, that's it. Nobody called, no experts, gave no. And he just basically, the defense attorney just fucking danced around the courtroom shouting that it's a murder. It's a murder. It's a murder. Hi, Lacey. Hi, silly goose. Oh, it's just silly. That guy was crazy. Yeah, right. But yesterday, he said that was evidence when the defense objected to it. Well, technically, the 911 call is evidence. It was entered as an exhibit. So, I mean, you can go catch 22 there probably. You probably remember the context he actually said it in. Yeah, we got another BG. We got Barn Guy. Zach Hughes, you've got Bike Guy. Delphi, you got Bridge Guy. All right. You know what? I was going to actually watch this last little clip of what we stopped at yesterday from day 2 to see if it was even worth us needing to watch it. And I'll be honest with you, I went and finished Karen Reed. I watched the Lori Vallow hearing. I watched a few people talk about the Karen Reed hearing. I never actually, I was just going to watch it and see. Hey, Straits. Hey, Anja. Hi, Mario. It's time to party. So I don't know. I'm going to.
Okay, Mr. Duden, were you able?
If you guys remember, so this is Dr. Nye. She's on the stand, biomedical engineer. She was originally hired. Her company was hired. Her company was hired to, see if this was even possible. Hey, the bias juror. Tell me everything I missed. I can sum it up for you. State of Iowa really sucks at investigations. They railroaded Todd Mullis, and he's innocent. She's a science guy. Yep, she's the science guy. So she was on the stand. So her company was hired, and her original job was to peer review another person, and I think their name was Bully, if I remember correctly, another person's report. If I understand correctly, I believe that the engineer Bully died, and so she was asked to do one herself. And then, so she does one herself. The state is like in this like crybaby mode about her using any information from Bully's reports instead of like her getting the information firsthand through police reports. And so they won't allow Bully's report in as an exhibit. And so like there's some like wishy-washy stuff to the whole thing. So he's saying he didn't receive something she was testifying to in discovery, and Todd's attorneys are like, yeah, you did. It's in the Dropbox. We gave it to you on such and such date. Judge says, take a break. Go see if you actually have what you're talking about. Come back and we'll figure it out. So she essentially is about, she's about done testifying for day 2. She leaves, but she's not able to come back until the afternoon of day 3. So when we get into like, we're not going to hear the end of her until after the next witnesses. So like it gets kind of confusing. Yes, exactly. The bias juror. Another beautiful example of quote unquote justice. But this is his last ditch effort right here. He's been denied his interlocutory appeal. He's been denied his appeal with the Iowa Supreme Court. He has been granted this post-conviction relief hearing, which is extremely rare anyway. His defense team is doing a great job. We will end up hearing, which we haven't yet, but we will end up hearing from the defense attorney in the trial who takes the stand in this post-conviction relief hearing saying, yeah, I essentially did nothing to help him. I mean, it's just such a high bar for a judge to be like, yeah, we're going to overturn or vacate your conviction. But I mean, he's got here, which is also very rare. So she obviously saw something. She saw something in the pretrial motions and discussions to make it so she decided to give him this hearing. Oh, is he silly goose? I mean, shit, more interest the better, because I think it's an absolute injustice, but maybe just like a preview, because the judge, I shouldn't say the judge, I don't know what I was, not the judge. So both sets of attorneys have until April 8th to submit their briefs from each side to her, and then she has, I want to say like 60 days. Don't quote me on that time, but she has a long time to be able to make a decision. I'm hoping because she's already heard all this evidence that she kind of already knows where she's headed, and we'll get a decision sooner or later. So, let me see. Cannot wait to see his old attorney on the stand. Oh God, I can't wait to see Hemisath on the stand. The fucking guy doesn't even know what UTC is. Central Standard Time. And then these idiots take this stand and then they get promoted. He becomes the freaking sheriff. Like how? What? What? Hi, Shaz. Glad you're covering it. I'll have to watch some past streams. Please do. Yeah, it's a great case for. The Innocence Project is who his attorneys are now. So he actually had an attorney who took interest in his case after 48 hours, after a 48-hour episode, and then she assembled a entire team of women, of female attorneys from the Innocence Project, and now has gotten him to this point. So, what else? No way. Good luck. That's fucking crazy. Mav, have you had time to learn about Google since the last trial? Maybe we should have Hemistath meet up with Cecil, and they can get it figured out. Okay, so here we are. Like I said, I was gonna watch this to see if there's anything even relatively important, but I didn't get that far. So I apologize that you're gonna have to bear with it. Bear with it. Why does that not sound right? Man, I fucking hate mornings. Like things don't even come out of my mouth correctly. It's like it's not even, my brain isn't even functional yet. It needs more sleep or caffeine or something. I'm gonna open a Dr. Pepper. It's only 9 a.m. and I'm starting early, guys. Starting early.
To identify if you had received the materials that were referenced in that footnote.
My belief, Your Honor, is that we have received the materials that have been disclosed.
Oh, fucking DB, that's hilarious. Oh my god, Bob covered Mullis. Bob, back off. This is T's case, bruh. That's fucking hilarious. I already had 2 copies. I only had 1. Maybe I needed another.
An exchange during discovery, so there's no dispute as to what we received. I think the dispute is to whether or not it's substantively enough for purposes of an expert evaluation or report, as they're required to include their data, impressions, and opinions. We're certainly willing to wait on our objection in order to talk about that evaluation, but what it sounded like when we left off, or at least my understanding, was that based upon a deposition that had never occurred, that information was going to be left out in order to be asked about. That information was going to be able to be requested at that deposition, but was not included within the report itself. So I think more so it's whether or not the data and impressions and opinions that would be included in the report are enough. And certainly, as our objections had been noted earlier, the answer was no. But we do not believe that there's any dispute as to what's been exchanged.
Okay.
So the state withdraws its objection for the purposes of continuing questioning, and will raise the objection again should we go outside the scope of what was, believed to be included in the report itself.
Do something with your hair.
Okay. We'll continue, Dr. Nye.
Come on, you guys. Like does somebody, like one of his friends or his family member, Frida Bird, hi Teresa, somebody, come on. Somebody, his friends, his family, they're watching this because they're like super proud of him. Like look at how far he's come. He's on Law and Crime, and everybody can watch him, and they're like, everybody tune in. My son's gonna be on Law and Crime. He's he's the prosecutor. And then this, like, somebody has to tell him, right? Like, this is my question. My question is, if you have this hair, how do you go into your barber and ask for a haircut? Do you say, like, you're just gonna leave this strip right here, just leave this strip right here really long, and then cut everything else short? Just right here, this one little strip from front to back on the side of my head. Just don't cut that. Like, how does that even happen? Do they like put a little clip in it to like make sure it doesn't get? The barber knows the deal. Somebody needs to tell him, dude, you gave it a good go. there. Like, it's time. Just shave your head. Just shave it. Or maybe talk to Nick McClelland. You guys are on the same side. Talk to him. See where the plugs come in. See how expensive it is. It's Iowa. It can't cost that much, right? Does not do good in the wind. This guy cannot drive a convertible. Ever. See the wind. Somebody rolls their window down. He's like, that's where, and he just holds on to his one little strip. His head is enormous, though. He's got to offset it. I was thinking that, like, he definitely does not have the head of a bald person. Like, he really probably shouldn't be bald. So that's when I brought up the whole meet up with Nick. But there's no way. I mean, he just put it in a little ponytail. He's like, all right, we're driving with the windows down, and then he's got a little ponytail in his hair. You gotta go. Oh God, he could never ride a motorcycle. No. Oh my God, imagine you're behind him. And he sees a little strip of hair blowing in the wind. It's like, so bad. So bad. And then I've always, it just doesn't, I don't, like, somebody had to have shown him this and been like, see, this is not working. This is not working. You have to stop. Just stop now. Sorry. Oh God, I'm gonna die over here. He could never have a sleepover. It's the one strip of hair is just laying across the pillow. It's just like 6 strands of hair. Oh, I'm such an asshole. I'm so sorry. He's more aerodynamic on a bike with the waving in the wind. And it's like his hair's just waving at people. It's like, hello. He braids it at night. I still think I'm gonna have a little curl in my hair tomorrow. Oh gosh. His jacket says private practice, but his hair says public pretender. Oh shit. This is, I don't know. All right, sorry. I'm gonna try not to do it every time they show him. But I just don't like these two guys. Corbin, you thought it was you thought it was a headset. I could totally see that. No, it's his hair, honey. It's just, hello. It's like Mrs. Doubtfire. Hello. That is awesome. It does look like a headset. Maybe we should all just pretend like it's a headset. Hi, Thomas. We missed you yesterday. We had all kinds of fun stuff happening. Oh, he's got like earmuffs on. It's cold in the courtroom. All right, sorry. I don't even have a lot of time today, and here I am just messing around. I'm so sorry. People are going to be like, you're so mean. You're part of the Mean Girls Club.
Remind you that you remain under oath. Ms. Thompson.
Your Honor, I want to proceed. I just want to say that I'm not sure that
Hey, Grace,
reflects our position on this issue, but I agree we should move forward. But I'd rather take this up at another time.
Okay.
Understanding I don't accept that representation, I agree that we should proceed.
All right, we will. And I will just question you. I know we did go a little bit late yesterday in order to finish with the witness. I have no idea what Dr. Nye's obligations are as far as time. And
TV, you know you're in it with
go
me.
a few minutes past 4:30 today, but that will be it. So
I want to be candid with the court that while this is a witness who is moving expeditiously. I do not think I'm going to be done with this witness by 4:30. I just don't see that being the case, Your Honor.
Okay, in that,
Right.
I didn't expect that you probably would be, and obviously we have cross-examination. I was just concerned about what the doctor's schedule was more than anything. So I
Let me speed this up.
wanted to let you know we weren't going to
This
be
is
able
why I
to
wanted to
go
watch it last night, because I don't recall there being anything super important, but
I think the question that I posed that led to this break was whether, Dr. Nye, you had an understanding of the relative weights and heights of Ms. Mullis and Mr. Mullis. And I think you provided an answer, but just because that was a few minutes ago, what is your understanding of their relative heights and weights?
My understanding is Ms. Mullis was 163-ish pounds near the time of the incident, about 5'1.5", and Mr. Mullis is about 10.5 inches taller.
There was height and weight for Ms. Mullis. There was information in her medical records and in Dr. Cruz's autopsy report. Is that right?
Yes,
Were those numbers different in terms of her height or weight?
they were consistent.
All right.
wait. Okay, so it's a little early for math, but I'm pretty sure she said she was 5'1" and that he was 10.5 inches taller. Did I hear that correctly? So he's about 6 foot. We were talking about this yesterday about how tall he was. I don't know why is she trying to make me do like this. I get it. You're an engineer and you've got 3 fancy degrees, but it's early and I've only had 1 coffee. Like, don't try to make me math so early. 6 foot, right? Right? Yeah.
And the information in her medical records reflected her weight and her height when she was alive.
Yes.
Okay.
5'12".
And
Smart ass.
I think you started to talk about this, but I just want to make sure we're on the same page since we took a break. It was your determination that it was not possible for the hypothesis that the corn rake in this case was swung into Ms. Mullis's body to be true. Is that right?
Yes, based on my investigation, that was the corn rake was not swung into her body.
And how did you reach that determination?
So again, applying the engineering fundamentals, looking at the wound pattern, externally and internally, looking at the intrinsic properties and geometry measurements of the rake, putting them together, understanding that we know that A, B, and C wounds happen first, and their wound trajectories are about horizontal with the long axis of the body. So you match.
Let me stop you right there. What does horizontal to the long axis of the body mean?
Like perpendicular. So perpendicular, near perpendicular to the long axis of the body.
Yeah, DB, they don't
That's the
stand up.
wound paths for A, B, C, and D.
Everything
So
is
if you
sitting.
match up the tines, which have a very fixed position and geometry, now I have a relative position of the rake handle has to be essentially along the long axis of her body. The rake handle is along her body. Essentially, like her buttocks would be contacting the handle upon entry for A, B, and C to occur. So then understanding that, you look at the swing options.
So you see that's what she just said. So for A, B, and C to occur from back to front at a downward angle, the handle of the rake has to be down by her butt. Because remember, Kelly Cruz, state medical examiner, is like, oh yeah, well, it doesn't really matter where it was. But yeah, I was told that it was like up here and the handle was like above her head. I'm wondering if it's the PCR thing or if it became an Iowa thing, because in the trial, they did stand up. So it might be a PCR thing. I don't know. I don't even know of another case I've ever followed out of Iowa except for this one. I'm trying to think of like, there might be one more, but that I rarely does anything like come out of Iowa, and it might be a judge thing. Yeah.
Aside from the multiple swing option, let's look at
Right,
the first
right.
swing option. And a swinging of the rake, overhead swinging of the rake, would generate much steeper angles of wound trajectory and did not match the physical evidence.
I want to show you I'm going to show you a demonstrative that we've identified as figure E. Let me just tell the state what this is.
Okay, I'm gonna bring up for anybody who doesn't like to see the wounds. Found this in a Facebook group, and I thought it was kind of interesting because it did help kind of explain what they're saying. Pause it real quick. I should have paused it before I brought that over there, but of course I didn't do that. Why would I do that? That's silly. Okay, so A, B, and C together. So the A, B, C, and D are all pointed down. E and F are pointed up. A is over here under the armpit area. So you have A and B, the tines never leave. So once she's impaled, the first time is A, B, C. A, B never leave. So the second time, A, B, D. As she tries to like get it out of her back, and then it shifts, and you can see the scrape here too, goes down to D. So the tines are still in A, B, and so now it's A, B, D. Then she gets it out of D, and then the tines are A, B, E, F for the third time. So, but the tines never leave A and B. They stay there the entire time. Yeah, I agree. And well, they agree too. Yeah, you couldn't do it. So the state, because of that, because now they have the biomedical engineer who's proving the rake could not be swung in that space. They're trying two different things. One, they're trying to convince the judge that maybe Amy died elsewhere, which makes no sense. And then what, he put her into couldn't get her out of the barn or the shed. There was a barn, but they couldn't get her out of the shed with the rake in her, but he somehow was able to get her into the shed with the rake in her, where his son was then sent to find her. Like, make that make sense. But, you know, they're trying to come up with any other excuse. And then the next one is that he, like, essentially took this corn rake and walked up to her and, like, shoved it into her. Like, pushed it. He keeps trying to compare it to like a stab wound, and both the forensic pathologist for Todd's team and the biomedical engineer is like, no, that doesn't make any sense. Like, you can't do that, and you can't have the wound E and F without having two other wounds. And she describes it like, take a plastic fork and try to stab yourself in the middle of your hand with a plastic fork. There's no way to only get one prong of that fork in the middle of your hand. Like, you would have to have other prongs hit your hand. You can't do it any other way. Okay, so the rake made the last two holes while in her jacket, meaning simply pressing into the tines made the holes. So there's only 4 holes in her jacket. At the trial, the jacket has 4 holes in it. Her body has 6. Now there's miraculously 5 holes in the jacket. But regardless, there's still not 6 holes in the jacket. And so at some point, the tines, as they come out of her back, they never leave her jacket. They're still inside the jacket. So it's almost like she impales herself kind of off to the right. I imagine it as like the rake is kind of up against a wall and she kind of stumbles over, like, because she's dizzy all day. Like, so she kind of stumbles over into it. Other people say that it could be on the ground. I don't know if you could actually prove either way which one it was, but somehow she has to have the impact to be able to get into the rake, right? Like, to impale herself on the rake. With wounds A and B. I don't know if that makes sense. So as ABC is number 1, so she hits ABC and she's like, shit, tries to get off of it. It comes out C and slides straight down to D and never leaves the clothing. Never leaves the jacket. So it's still inside the jacket. She kind of falls like, oh shit, like kind of falls back against it because she's unsteady, right? Sorry, I had to cough. Oh, hey, Paul. Yeah, wound D had no hole in any of the clothing layers. You don't throw the rake into Amy, you throw Amy into the rake. So like okay, let's think of it like that. And then she tries to get off of it and you have to push her back into it. Okay, so let's say the rake is standing up, right? And Todd comes in and he shoves her against the rake. Which, mind you, as even though you might think that theory's good, this prosecution hasn't even come up with that one. They're just like, you push the rake into her. You'd walk up and you pushed it in. You just push it in. So, okay, so you shove her into the rake that's leaning up against the wall, and then she tries to get back up. You'd have to shove her again, like onto it, a couple of times. Hey, Papa G. Into, well, I guess it would be onto if it's on the ground, and into if it's, well, I guess it would still be onto because it's impaled. Yeah, you're right. Fine, Kathy Spank. Okay, not sure if we are here yet, but she says it's similar to a flathead screwdriver, so just pushing 4 flatheads into a human. Okay, turd. Yeah, we'll get there with this witness. Okay, let's keep going. Now, because those wounds are not.
Would looking at some demonstrative exhibits assist you in your testimony in describing how you considered the hypothesis of whether Mr. Mullis swung this rake into Ms. Mullis's body?
Yes, how I can demonstrate how I analyzed it, yes.
Okay. You're looking at I think there should be a figure on the screen in front of you, which is we've identified as figure E. Would using figure E help you illustrate your testimony?
Yes.
All right. And can you explain how you determined that swinging an overhead swing would not have, is not a hypothesis that works in terms of how Ms. Mullis received these injuries?
Yes, so what this entails is the figure that demonstrates the wound trajectories for all A to F wounds, and that A, B, C, and D are essentially, like we talked about, perpendicular to the long axis of the body. In an overhead swing, based on the properties of the rake, when you try to swing it into a person, you're creating much steeper angles. So therefore, the type and direction of forces that are necessary to cause Ms. Mullis's diagnosed wound pattern isn't generated from the swing.
So there are different angles at which, depending on the distance of two people, in terms of where they're standing vis-a-vis each other, there's different angles that can be generated by an overhead swing depending on the distance between the two people. Is that right?
So if you want to generate the maximum speed, you mean, then you have to be farther apart?
Well, my question is just that if, for instance, if in this situation, in this scenario where you're assuming people of the relative heights of Ms. Mullis and Mr. Mullis, if you're considering a hypothesis of whether someone standing behind Ms. Mullis and swinging the rake overhead, how that would contact Ms. Mullis's back.
Yeah.
Depending on the distance between the two people, that angle might be different. Is that right? The angle at which the rake hit Ms. Mullis's back.
So you want the rake tines to hit. So that you're not talking about the other parts of the rake.
Let me ask you a better question.
Okay.
Would the distance between two people in a hypothetical where a person is standing and then a person is standing behind them swinging a rake overhead, would the distance between the two people impact the angle at which the rake tines hit their back?
Well, if you have them closer, the rake tines might not even hit their back at all.
And why is that?
Because of the, again, intrinsic properties of the rake. It has a specific length, has a specific entry point if you want the tines to be in there. So they have to be positioned and oriented in such a way that the rake tines enter her body while she's hyperextended.
And is there, could you envision in testing this hypothesis any sort of position where a person could have been standing behind Ms. Mullis and swinging the rake overhead where the specific injuries with the specific pattern and trajectory that Ms. Mullis's injuries had could have resulted?
No, we tested
No.
standing upright.
Because the four initial wounds, A, B, C, D, are all at the wrong angle. And then you have E and F at the other angle. Like So he would have to be hitting her from different like positions around her body.
Various angles of bending over, lying flat on the ground, the way the rake tine is built and her nature of her injuries, and knowing that she has to be hyperextended at the time the tines enter to cause A, B, and C, the angles don't match. The position and orientation doesn't match. Therefore, the mechanisms, the type and direction of forces necessary to cause those specific diagnosed wounds don't match.
I'm going to show you figure F. Let me have you take the demonstrative away and let me ask you a different question. I mean, you've talked about the rake being the hypothetical that the rake was swung overhead. There's other ways that a rake could be swung into a person's back. Is that right?
Yes.
I mean, another way would be through more of a baseball swing.
Yes, a
swing
lateral
sideways.
swing. Yes, a sideways swing.
A lateral swing. Did you consider that hypothesis as well?
Yes.
And could you prove or disprove that hypothesis?
Yes.
Which did you do?
Disproved it.
And why is that?
Again, based on the intrinsic properties of the rake and the injury pattern. If you're going to swing it sideways into the body, you would have a more vertical oriented wound pattern. That's in line. That's not what she has. Additionally, the wound paths through her body wouldn't match. So the mechanism of injury necessary to cause her diagnosed wound paths aren't generated with a lateral swing.
You talked earlier about your understanding in this case based on the medical diagnoses that Ms. Mullis's back would have been hyperextended at the time that she experienced these wounds.
So biomechanically, that is true as well.
Right, and would the fact that her back was hyperextended and to hyperextend her back, that her arm, at least her right arm, would have had to have been back, did that impact her analysis as to whether any kind of swinging could have caused these injuries?
I mean, the arm could get in the way again as well. So if you're talking about position and orientation, in order to get that A wound, which is on the side of the chest, with your arm, if you're trying to swing it, the arm is in the way, essentially.
What about a hypothetical where instead of, in a hypothetical, somebody of Mr. Mullis's size standing behind Ms. Mullis, they're facing each other at the time in this hypothetical that the rake is swung? Did you consider that hypothetical?
Yes,
And what was your conclusion about the possibility of that hypothetical?
it was that hypothesis is disproven.
And why is that?
Because again, of the wound paths and the rake, if you swing overhead, you're going to have upward trajectories. And then we already know that E and F can't be generated first because it's essentially in the middle of their back. You can't have two tines entering in the middle of her back without a third tine contacting. And we only have two wounds that are upward trajectories.
If someone had swung the rake into Ms. Mullis into wounds E and F, would there have to be other wounds in that same trajectory?
You have again, a third tine sometime would have to contact it because of the location of the wounds and the spacing between the tines.
So I think we've shown you, well, I want to ask you this. I mean, is it possible for somebody to have swung the rake into any of these wounds, wounds A through F, and had one tine make contact with her body and all of the other tines missing her body?
So again, we talked about how the wounds are essentially in the middle of her back. The nature and diagnosis of her wounds and the intrinsic properties of the rake, you cannot insert one tine at a time.
Does the condition of Ms. Mullis's coat that she was wearing at the time she came to the hospital, does that factor into your opinion that the rake could not have been swung into Ms. Mullis?
It supports it.
How's that?
Well, again, she has 6 holes in her body and there's 4 tines in the rake and there's less holes in the coat than there are in the body. So if you swing it, even though we've proven that the trajectory doesn't match with any kind of swinging that we've talked about, if you take that rake out and re-swing it, you still have less holes in the coat than you do in the body. So that doesn't matter. So that's, again, further support that a swinging incident did not cause these injuries.
Given your training,
Pretty sad that you need a biomedical engineer to tell you that. But I mean, I guess in Delaware County, Iowa, you don't know what Central Standard Time is. So, it is what it is. I guess you do. There's not enough holes in the clothing to show that the rake was swung at her multiple times.
training and expertise in biomechanical engineering and the investigation that you conducted in this case, Dr. Nye, can you think of any position that Ms. Mullis and a hypothetical assailant of Mr. Mullis's height could be in vis-a-vis each other? Any position that they could be in relative to each other where, from an engineering perspective, it would be possible for someone to cause this wound pattern in Ms. Mullis's back from swinging this corn rake into her?
So I analyzed the information that's available. There's no, information that there's a trapeze available. I can't analyze every single 1,000,010, possibilities. Those are all unlikely. I have to take into consideration the evidence in the case. And engineering analyses, like we talked about, don't take 2 seconds to do, right? So my analyses are based on the information that's provided and the scenarios that are provided. But from my analysis of the case, given what I have, there was not an alternative scenario that fit the physical evidence and the science.
Did you consider the hypothesis that someone pushed Ms. Mullis down on the rake?
Yes.
And did you determine whether or not that hypothesis was possible?
I considered it, but I considered it.
And could you prove or disprove that hypothesis in your consideration?
I disproved it.
And why is that?
So when you push someone, you are imparting horizontal velocity as well as rotational acceleration to their body. So when you push someone, they're going to essentially rotate, kind of flip. And if this rake we talked about is top heavy. So if you're falling on the rake with horizontal and rotational acceleration of your body with your upper body, and you hit the rake tips, you're going to flip this rake. And if you flip the rake, then you don't have the rake tines pointing up in the manner to cause the injuries.
And when you talk about it generating horizontal force, if someone is standing in front of me and shoves me, hypothetically, 2 hands into my 2 shoulders, that horizontal force, where is that going to send my body?
It's going to send you backwards and rotate, because a person standing upright, their center of mass is about 55% of their standing height. So about navel. So we're already slightly top heavy, generally speaking. So now if you push someone above their center of mass, now you're going to move them backwards and rotate them. So basically you're going to flip them with their feet coming up, in a sense.
Your Honor, I think I probably have maybe another 20, 25 minutes. I think this might be a good time to stop for the day, and we will endeavor tomorrow to finish promptly.
No, that's fine. Thank you for letting me know this is a good time for a break. We'll go ahead and recess for the night. Council, maybe if you just check in with me back in chambers before you take off. I'll plan on seeing everyone back tomorrow. Thank you.
This prosecution is top heavy. I think he's a little light on the top, though, Kathy. Well, I guess maybe the size of his head. Okay, hold, please. Let me get the other one. Let's get day 3. Day 3. Where are you? Day 3. That's day 4, day 5, day 6. There we go. Here's day 3. All right. Oh, I know. Great. I was like, what? Chris Massey got fired. Proctor done. I mean, he essentially has been done. Like, we all knew it was coming, but so Mav says, I don't know if I agree she disproved that someone could push her onto the rake. So you'd have to think then that it's just like somebody repeatedly pushes. I think you could push someone straight back without them bending backwards. Like it pushes her back into the wall where the rake is. But I still think that you'd have to then push her repeatedly. Or you go, what? So the next ones are where she's trying to get off, and you go back to that theory. He was on unpaid leave, I believe. I don't think he was unpaid. I actually don't remember. I should not even answer that because I don't remember. Okay. So this is day 3. I have seen some of day 3. This is when we decided we were going to watch it together. So I've seen some of day 3, and then the rest of it's all going to be brand new to me. So after it's like the rest of day 3, all of 4, 5, and 6 I've not watched. So we'll get a blind reaction on that one.
Probably 30.
Oh, here we go. We get Hemiseth. What? Yeah, it was unpaid. He could have hit her with it once. I still don't know how he can hit her with it at all. He can't hit her with the rake. I think that's pretty well proven. That there's no way with his size, her size, and the space they're in that he could swing a rake and hit her and it go into her body at the angle that it went in. The other issue is if you go with what Kelly Cruz said, there is the handle of the rake was facing above her head. I don't know. I don't know. You guys know maybe I have some cognitive bias or something because I don't think he did it. I think it's an absolute accident. Oh. Is this Hemiseth Jr. over here at the prosecutor table?
Are we picking back up with Dr. Nye, or are we interrupting her testimony?
All right, let me see.
To accommodate another witness's schedule?
Yes, Your Honor, counsel, we have conferred, and we are going to call Sheriff Hemiseth first this morning due to scheduling. Dr. Nye is available this afternoon.
Okay, that's terrible
We
audio.
are planning to move Mr. Castle to tomorrow, and we may finish a little early today, but I don't want to promise the court. And then I just have one housekeeping matter.
Well, the prosecution ends up essentially agreeing that there isn't enough room, which is why they have now changed it from that he struck her with it to that he pushed it into her. So they've conceded that there's not enough room, essentially, unless something happens in the ones I haven't watched yet.
And counsel, 301 and 346.
I don't know if it's their mics or what.
Good morning, and yes, Your Honor, that is correct.
All right, those will be admitted. Any?
A little bit about the Delaware County Sheriff's Office.
Well, I shouldn't say they've not gone, okay, fine, so maybe he didn't hit her. They're essentially now trying to say, well, what about this and what about this? Like he could have done this, this, and this. And it's like, well, that's not what your state's theory was. So why aren't you sticking with what it was? Their audio is terrible. Hold on.
We have a secured evidence room.
I think it has to get better.
Where it is or how big it is?
It's within our sheriff's office, and it's probably 30 feet by 40 feet square.
Yeah, I can't hear it all either. And I have
What I envision as far as
into the system.
in your investigation is mistaken about a fact.
I don't think they had their mics
We
on.
can show you Exhibit 400. I believe this is the.
It's not my stream, it's their stream.
Oh, you talking about our old office?
Wait, Bob's watching this day?
Do you also consult with first responders or medical personnel in certain investigations?
Well, he's missed a lot then.
Yes.
If another person is in your investigation is
You
mistaken
know,
about a fact.
The
does that
Hemiseth
affect
doesn't know what
your
UPC is. The audio will
Can you
fix.
rephrase that? I'm not quite sure what you mean by that.
Sure. If another person who you are working with in an investigation, like a first responder or a medical examiner or another investigator, makes a mistake, in your experience, would that affect your investigation?
It's situational based. Like I said, every case is fluid. Things change.
If someone tells you it's a blue car and it ends up being a gray car, is that a mistake?
Yes.
Have you ever thought you saw someone you knew in Walmart and it turned out it wasn't who you thought it was?
Objection relevance.
Overruled.
Why'd she pick Walmart?
I don't believe, no, I haven't, not in Walmart.
Someplace
Not at
I'm trying to
Walmart.
give you a hypothetical, I think.
I
Sheriff,
understand, I understand, yes.
have you made a mistake before?
Oh, yeah, yeah, nobody's perfect.
When you were conducting the investigation into Mrs. Mullis's death,
Can we talk about what mistakes you made? Have you ever made a mistake while testifying? Have you ever interpreted a report and read it completely wrong and then it be on television and everybody make fun of you? Oh yeah, for sure. Yeah, I absolutely have.
How did you communicate with other people that you were working with in the investigation?
Yeah.
In person, by phone.
Did you send emails?
Yeah, I'm sure I did.
Did you receive emails?
Yes.
Send or receive text messages?
She's not as good of an attorney, in my opinion. At delivery, she may be very intelligent, but at delivery, like Tara Thompson has a delivery and a quick wit about her, where I think it's so much better. But
Yes.
Did you have meetings?
Yes.
Did you share reports with each other?
Yes.
Did you have
I got
access
you, Amy.
to body cam or audio recordings of interviews?
Yes.
What about video of interviews or interactions with witnesses?
Yes.
Would all of these documents and communications be a part of your investigative case file?
Yes.
that's okay. I
Going
talked to
back
the
to Exhibit 400. Let me make sure I find the right page for you. I think it's 222. Do you recall
I almost
the
wonder if I should speed it up a little
policy or
bit.
the procedure in the Sheriff's Office for report writing in 2018?
No.
If you could take a quick look at page 222, which should be on the screen in front of you.
They're both pretty slow. Because I've never seen this. Was I supposed to have read this at some point in my career?
Have you reviewed that?
Yes.
Does it contain information about how to write a report or when a report should be written?
Yes.
Oh, crazy, Don. See, Tara never takes this long.
Do you have an investigative technique or procedure that you use to determine how someone was injured?
No.
And you've testified previously regarding Amy Mullis's death in your investigation.
Yes.
And we can show you this testimony as well, so I don't want you to feel like I'm trying to trick you. But do you recall testifying August 29th, 2019 in a deposition before the criminal trial?
Yes.
And for the record, that is Exhibit 258, which we've already admitted. And then do you recall testifying at the criminal trial September 19th, 2019?
Yes.
And then you've testified in 2023 in another deposition in this post-conviction action. Is that your memory?
Yes.
And for the record, the PCR deposition is Exhibit 327. Did you testify truthfully and accurately each of those 3 times?
To my best of my ability, yes.
All back answer.
Have you learned since then that your testimony at the criminal trial September 19th, 2019 was false?
I don't believe so.
What?
Have you learned that you stated facts that weren't true?
Nothing that was pointed out to me. No.
Oh my
Do you
God.
recall in your 2023 deposition learning that you were incorrect about the times of Google searches?
Yes, I didn't have a clear understanding of the UTC time at that time. Yes.
How embarrassing. Oh, I was telling you guys at the beginning of the stream that I did get some of the documentation. And so one thing that came in the documentation for one of his appeals was during his original trial, there was a jury question and the jurors asked the judge if they could explain UTC time, if the judge would explain UTC time and what the accurate time on the reports actually was. And the judge wrote back to the jury and said, all evidence has been submitted and I won't be explaining anything. So the jury had a question about this whole UTC time and what time these searches were actually happening. And they were never given an answer on what it was. All because this guy, Mr. Expert on Google and Cecil's brother, couldn't give them an explanation. And Todd's attorney didn't hammer home that these searches were not done in the middle of the damn night.
And Mr. Himmelsath, I don't want to repeat all of your prior testimony, so if my questions don't make sense, please let me know. But you have, am I correct that you have a 2-year degree in police science?
Yes.
And does that 2-year degree that you have cover physics?
That I'm not sure. I'd have to go back and look.
Do you recall learning any engineering principles in your studies?
No.
Anything about biomechanics and the body?
No.
Did you learn about accident reconstruction?
Yes.
Would that have been focused on motor vehicle accidents?
Yes.
And are you a lifelong resident of Delaware County?
No.
Where did you live before Delaware County?
Objection, relevance.
Overruled.
Up in Howard County.
Is Howard County considered a rural area or a farming community?
Yes.
In the course of your experience in your law enforcement career, have you responded to farming accidents?
Yes.
When did you get involved in the investigation or learn about the death of Amy Mullis?
It would have been on the evening of November 10th, 2018.
Do you recall what time?
I came on shift at 5, and I believe around 5:30, 6 o'clock range is when I became aware.
Do you remember how you became aware?
I think I read a call page, and then I spoke to Deputy Thompson.
What did you do after you read that call page and spoke to Deputy Thompson?
Deputy Thompson went out to the farm with me, the Mullis farm.
To the Mullis farm?
Yes.
Do you recall approximately what time you got there?
I think around 6 p.m.
All right, here,
And this would have been November 10th, 2018?
Yes.
And that is the day that Ms. Mullis died?
Yes.
And I don't want you to assume, but do you remember, was it dark outside?
I believe so. Yes.
Was it cold?
Yes.
Was there snow on the ground?
Yes.
Why did you want to go to the farm?
Well, I wanted a better understanding as far as what happened. Deputy Thompson advised me of what had occurred, so I just had asked him if he would take me out to the farm and just kind of walk me through it. So we went to the farm and essentially did a consent approach to the scene, you would say, or the reported area, and Deputy Thompson walked me through.
And the Mullis family gave you consent to examine the shed and the outbuildings.
Yes, it gave consent to Deputy Thompson.
Did you talk to Sheriff Leclerc before you went to the farm?
I don't believe I did, no.
You talked to him while you were there, though.
I honestly don't recall if I did or not.
Would you disagree if the phone record showed that you were on the phone with Sheriff Leclerc while you were at the farm?
Yeah, if the phone record showed it, yes. I don't recall speaking with him.
So you don't recall what you talked about then?
I do not know.
Is there a report that you completed regarding your activities on November 10th, 2018?
I didn't have access to all my reports for today, but I believe there would have been.
Okay. We'll try to look and see if we can find a report for you, but we'll move on, okay?
Okay.
Do you recall walking around the farmyard that night?
I wasn't walking around the farmyard, but I was walking around the red shed. Yes.
Okay. And did you see anything unusual?
You'd have to be more specific than that. What do you mean by unusual?
Well, you previously testified that you saw nothing unusual outside of the shed.
Correct.
Okay. And that included that you didn't notice any footprints or tracks. Is that still your recollection?
Correct. Yes.
Did you see surveillance cameras while you were there November 10th?
No.
How wide was the door to get into the shed?
That I'm not sure. It wasn't very wide.
Did you take any photographs while you were there?
No.
Have you reviewed the photographs that Deputies Thompson and Holub took earlier in the day?
It's been a while since I've seen them, but I did see them at a later date.
Would it help you if you could review those today?
I have a general understanding of the majority of them.
Okay. So is your testimony that you don't know how wide the doorway was to get into the shed?
And not to exact, no. Not exact measurements, no. But I do believe we have photographs of that.
Okay. Could you and I have walked into the shed together, arm in arm?
I don't think so. If my memory serves me right, it's 2 to 3 feet wide, maybe.
Did you try to move the door?
I did not.
How wide was the aisle or the walkway once you entered the shed?
Again, off memory, I believe around that 30-some inch range.
And you would defer to reports that you had written?
Well, we took photographs of the scene.
Can we show Exhibit 311? Mr. Himsath, I believe these are photographs taken by the Delaware County Sheriff's Office that you might be referring to. And they were tendered to me as a PDF that has a total of 20 pictures, so we'll have to scroll through. Is this the shed that you were referring to?
Yes,
And I'm sorry, Nicole, the opening there, is that the door that you were referring to?
yes.
And then if we can go down to 19, I'm sorry. Do you know what this picture is showing us?
Yes.
What is it?
This is that alleyway. You come into the front door and then when you immediately look left.
So this would depict how wide it was. This is how you documented it?
Yes. Well, I did not document this.
Your sheriff's office, your investigation did?
Deputy Thompson did right after the 911 call.
Okay. How tall were the chemical totes? Because the picture doesn't go all the way up, right?
I believe they're too high because I don't think a third one stacked on top of that would clear the door clearance. I'm not
Was
sure
it
though.
above your head?
Yes.
And how tall are you?
Pretty short.
I think I'm gonna have to ask you to be a little more specific there.
Like 5'7".
Okay. So more than 6 feet?
Yes.
Were they taller than 7 feet?
Yes.
And then if we could go back up to 18. Page 18 of 311 for the record, I'm sorry. All right, Mr. Himsath, what are we looking at here in the middle picture?
Yeah. So you go down the alley where you see in the corner rake laying on the ground, and then you look immediately to your right, and that is displayed just down that walkway. That's the animal carrier crate.
And these are these the only two places you can walk in that shed?
Yes.
And this is the documentation we have of how wide that area was as well.
Yes.
Did you walk down towards the pet carrier while you were in the shed?
Yes.
And did you make any observations about the carrier?
It's half pulled out on the shelf.
And what are we seeing there in the photo under the pet carrier?
Some grain augers.
What is a grain auger?
It augers grain.
For those of us that aren't farmers, what does that mean?
It means it moves the flow of grain through a tube.
And so the green and the black long cylinder objects we see in the pictures, those are the augers,
Yes.
and they move,
Well, they don't right there.
but they can move.
Yeah, they need to be inserted into a steel tube, and then a motor runs that and augers grain.
So there's a piece of them, like the circular, the rounded piece that moves around. Is that right?
No, this would just be like a smaller version would be like an ice auger.
I'm sorry, I still don't know what that is, but did you step on these augers?
No,
Did you touch them?
no,
Did you attempt to manipulate them or move them in any way?
no.
I want to show you Exhibit 269 now. When you're in that walkway, what's to the right of you?
Be like a throw bale wagon for hay.
Did you make any observations about what was in that wagon?
I don't recall.
Have you seen this photo before?
So there's tanks in the wagon.
I'm sorry, can you repeat that?
There's tanks in the wagon.
Tanks.
Water, chemical tanks. The way that's what this picture displays.
Do you also see a stuffed animal, a kid's toy?
Yes.
Counsel, just for the record, which exhibit is this? There's a number of stickers on it.
This has been marked 269 for the purposes of the post-conviction. At trial, it was, I can't read that, 103. Thank you. Okay. You can take that down. Thank you. Mr. Himsath, did you talk with Todd or Tristan Mullis on November 10th?
No.
Did your other deputies in your office talk with them?
Yes.
Did you review their reports?
Yes.
And have you reviewed any body cam, video, or audio of those interviews?
No.
Did you also review a report written by the sheriff at the time, Mr. Leclerc?
Yes.
And I believe these have already been admitted, but I'm referring to Exhibit 201 and 221 regarding Sheriff Leclerc's report and his deposition. Have you had an opportunity to review any of the depositions given in this matter?
Not of other people, no.
Okay. And then Exhibit 318 is Thompson's report and 264 is Holub's report. Do you recall whether your theory when you left the farm November 10th, what your theory was regarding how Ms. Mullis died?
I honestly didn't have a theory. I asked Deputy Thompson to walk me out there or take me out there and to describe what was explained to him. My next step after that was just the autopsy.
When did you learn there was going to be an autopsy?
I believe the next day.
When you were on the farm and in the shed, did you find anything that disproved the idea or the theory that Ms. Mullis had tripped and fallen?
No.
So you said a moment ago, I think, that the next day you learned there was going to be an autopsy. Do you remember who you learned that from?
I don't. I'm assuming that was communicated from the hospital.
Do you recall having conversations with Mr. LeClaire?
Well, we had a lot of conversations. John and I did. He may have told me, or Mike Kroppel. I know Mike Kroppel with DCI was contacted. John had contacted him, so I may have heard it from Mike too.
So, John or Mr. LeClaire was having conversations with DCI agent Krappel,
Yes.
and were you a part of those, or you just were told about them?
No, I wasn't part of those. I was just told about it.
What else happened on November 11th?
November 11th.
Yes, the second day of your investigation.
I believe I came in and then I was briefed on the rest of it. We had conversations with DCI. I talked with John, and the next step was, I believe I had conversations with DCI Special Agent Mike Kroppel about attending the autopsy. That was the next thing I did, I believe, in the case.
Were you aware that Mike Kroppel told LeClaire to lock Todd into his story on the 10th?
Objection, hearsay.
Overruled.
I learned that from reviewing his report.
Do you recall any other investigative activities on the 11th?
Not offhand, no.
Do you know what happened next in the investigation?
I went to the autopsy.
Do you recall what date that was?
I don't.
If the autopsy report is dated November 12th, 2018, would you accept that?
Yes.
There's been testimony about another deputy we haven't talked about yet, Keith Rowley.
Yes.
Who's Keith?
Keith was a deputy at the sheriff's office during this time.
And is he no longer a deputy?
Correct, he retired.
What did you learn about Deputy Rowley as it related to your investigation?
We had learned that he had a previous affair before this incident with Amy Mullis.
What were the dates of that affair?
That I don't know. I was just told it was way before this incident, and that him and his wife were in a good place at the time that this incident occurred.
For clarity of the record, when this incident occurred, you're talking about Amy's death on November 10th.
Yes.
So there's been testimony about clearing Deputy Rowley as a suspect. Do you recall that?
Yes.
Were you involved in that?
Not directly, no.
Why was that?
That was between the sheriff and DCI.
So were you indirectly involved in that part of the investigation?
Yes.
What did you do?
I was in office. I don't remember the date of it. I was in the office and Keith had came in to the office. I believe DCI was present within our office, and Keith had asked to have a conversation with us quick and in the sheriff's office. And that's when he had disclosed to us that he had a previous affair with Amy. He was currently working that day. And then that was it. It was short. It was brief. I left it up to John and I think Mike Kroppel or John Turbot to address that.
Okay. Can you tell me a little bit about what a patrol log is?
Patrol log is a daily activity report. You write down calls for service, town time, in and out town time.
Do you complete one every day?
I do not.
Why not?
If I get busy, I just don't have time to fill one out.
Are you supposed to complete one every day?
I guess I've never been told that I had to, but we had an understanding that if I get busy during the day, I don't fill one out.
Is there another
He's the sheriff now.
another avenue to see where a deputy was during patrol?
Yes.
What's that?
Well, there's actually, yes, we have two GPSs in our car, one called MACH and one called ADL. MACH. And then the other called ADL.
Were you using both of those in 2018?
Yes. No. Yes, we were, sorry, yes.
And we have some prior testimony that that could be reviewed by the sheriff, those
Correct.
GPS document. I don't know if I should call it a document. How would you describe it?
I've never accessed it. So I just know it's called ADL. It's a GPS in our car. When we start our car up, it activates. And then if we shut our car off, I don't know how long it stays on. We've never been told at that time what it consists of. We just know it's a GPS system and the sheriff had access to the platform to view it.
Did you retain any
You're
of that
the
information in
sheriff
your?
now, so you
I
should
did not.
know.
Have you reviewed it since 2018?
Reviewed what?
The GPS information, data?
No, it's a platform, and I was told that the software, there's a certain time period it's retained for, and then it's gone. I don't know what the retention period is. Like I said, I didn't have access to that.
Okay. And we previously
now.
admitted exhibits 208 and 209, which are patrol logs. And if we'll pull those up for you here in a moment.
Yes, mama. It's America's finest.
Council, for whatever it's worth, I show 208 is being admitted, but not 209. I don't know if you.
Yes, Your Honor, we were just
double check
conferring about that,
Okay.
and I believe we have an agreement to admit 209 as well, just so the record is clear.
Okay. Should I admit 209?
Yes, Your Honor.
All right, thank you, Mr. Rocky.
Mr. Himmelstadt, on your screen, are you seeing exhibit 208? 209? I'm sorry, I can't see that probably. All right, 208. Have you seen this before?
Yes.
What is it?
Patrol log.
For who?
Keith Rowley.
And this would have been in addition to the GPS information and data that the sheriff reviewed.
I don't know if we reviewed it, but we have it.
As far as information regarding where Rowley was at the time that Amy Mullis was injured.
Yes.
And then if we can flip to 209. And scroll so that Mr. Himmelstadt can see the multiple pages. And when you are ready, you can let us know what these are.
Patrol logs.
And do these include other deputies in addition to Mr. Rowley?
Yes.
Do you know if Deputy Rowley responded to the dispatch on November 10th, 2018 regarding Mrs. Mullis?
No.
And do you recall testifying previously that Deputy Rowley was nowhere near the Mullis residence?
Yes.
Is the basis for that statement the patrol log and the GPS that we don't have to look at today?
It's what I was told from the sheriff.
So you don't have any personal knowledge about how close Rowley was to the Mullis farm?
No.
Do you know if you learned about Rowley and reviewed the GPS data before autopsy or after?
I didn't review any of that. That wasn't my responsibility in this case.
Okay, but maybe I'm misunderstanding. You said you were in the office with the sheriff while he was reviewing it?
I was present after we briefly spoke to Keith, and he had brought it up on his computer and started reviewing it. I don't believe I stayed in there the whole time. I had other avenues that I was working on, and I just had asked him, I said, please preserve that when you're done. He finished, obviously, and he had communicated with DCI that Keith was not near that location.
At that point, did you consider him cleared as a suspect?
I believe that's what John Turnbull and Mike Kroffel and I had. I didn't specifically come out and say he's cleared. That was a determination from Mike and John.
You guys know who he's talking about, right? And why they're talking about it? Because I had to step away for a minute, so I don't know if they explained who this is. He's talking about the deputy that Amy had an affair with 5 years prior. And that they tracked, that the sheriff at the time went in and tracked the location, the GPS of Deputy Keith, to see if he was a suspect in Amy's death. So I don't know if they explained that, because like I said, I had to step away for a hot minute, and I don't know if that got told, like why we're actually talking about him and why anybody's even looking at the information from his vehicle.
And if you're clearing a suspect, does that mean that you've already decided there was a crime?
Yeah. Or a suspected crime.
Okay. Let's move on to the autopsy.
Okay.
Just getting jiggy with
You would have
it.
attended that at the medical examiner's office in Ankeny, is that right?
Yes.
What did you take with you when you went to the autopsy?
I took the corn rake and the clothing from Amy.
And have you seen those since the autopsy?
Yes.
When have you seen them?
During trial, several times, I guess. I don't know how many specific times.
Okay.
I brought some of the stuff up the other day in bags.
Right. It was here in the courtroom earlier this week.
Yes.
Have you looked at it in the evidence room?
I wanted to ask him if he knows what GPS stands for. Oh, that'd be fucking great.
Well,
Just once, yes. That was post-trial.
have you looked at
Stuff up the other day in bags.
Right. It was here in the courtroom earlier this week.
Yes.
Have you looked at it in the evidence room as well?
Just once, yes. That was post-trial.
Why?
During the post-conviction?
Yes.
What did you do with the corn rake during the autopsy?
I just brought it into the medical examiner's office and gave it to the technicians, Kelly Cruz.
And were you in the room with Mrs. Mullis's body?
Yes.
Did you make any observations about the medical examiner and her assistants in the corn rake?
No.
You didn't see them
Didn't
with the corn
observe
rake?
Yeah, they reviewed the corn rake, yeah.
Oh, so you did observe something.
Did you come to any conclusions during the autopsy about the corn rake?
I did not. I was there just solely for observation.
Did you complete a report about your observations?
No.
Do you think you should have completed a report?
She's all, did you observe anything? Did you observe anything at the autopsy? He's all, I didn't observe anything. She's like, well, what were you there for? I was there for observations. This is so silly. This guy is an idiot.
Well, no, because the reason why we take somebody to autopsy, that's for their determination.
What did you and Dr. Cruz talk about?
We didn't talk about much. She did her examination. I just stood by, and then we talked about her conclusion at the end about that it was, she was going to rule it a homicide, or as a possible homicide.
Did you tell her how Ms. Mullis's body was found?
Yes. I gave her the description that was explained to me, yes.
And that was a description that Deputy Thompson and Holub had gotten from Todd and Tristan Mullis?
Correct.
So what?
Right. So Todd and Tristan Mullis give a description to Deputy Thompson and another deputy, and then Deputy Thompson tells Deputy Hemisath, and then Deputy Hemisath tells Kelly Cruz, and Kelly Cruz says it's a homicide. What? He's such an idiot. DB, did you not hear his testimony for the trial? If you don't watch the beginning, if you don't watch the first trial, you at least have to go and watch this fucking guy testify. He's such an idiot. I should totally clip the UTC thing. So, but remember, the prosecutor is pissed off that the biomedical engineer got the information from the other biomedical engineer instead of actually getting it from the source. Yes, he's sheriff now. He's sheriff now. DB, this guy doesn't know what UTC is. He was asked directly, do you understand what UTC is? And his reply was Central Standard Time. He also states that he performed, that's how he says it, he performed a search warrant on Todd Mullis's Google email account, and therefore every search that was associated with that email account comes from Todd's iPad, and Todd did it. And so when he's asked if he compares it to the Celebrite report, he says that he doesn't need to do that. He doesn't need to do that because he knows that everything he has gotten is from the Google search warrant that he performed. And the defense attorney's like, and if you look this up on the internet and it told you that you were wrong, what would you say? And he's all, well, I don't know. The internet's never told me I'm wrong. And then he gets promoted to sheriff. You never had the internet. Nope, never had the internet tell us. No, I'm not going to stop, DB. This is for reals. This is for reals. This is the guy that they have on the stand as their, well, they don't have to do it. There's no Daubert in Iowa, but this is their expert on the Google searches. So yeah, the last 5 searches in the search history match. So all those searches had to come from the iPad. And it doesn't have anything to do with the Google address, because that Google address is from the iPad, and therefore the iPad is Todd's, and therefore Todd did all the searches. And no, not the same judge. No. Oh, yeah, this guy. It's honestly scary. I know. I laugh, and then Fish is like, it's funny, but you have to think about it. And she said what like Laura's saying, like, you have to think about it. People are getting convicted and sentenced to life in prison based off of idiots like this.
Did you have a first? And that was a description.
Then he comes here and he's like, I didn't observe anything at the autopsy. Well, what were you there for? I was there for observation. Like, what, you want somebody to observe you? What the fuck are you talking about, dumbass?
That
Homicide, or as a possible homicide.
Did you tell her how Ms. Mullis's body was found?
Yes. I gave her the description that was explained to me, yes.
He is the second.
And that was a description that Deputy Thompson and Holub had gotten from Todd and Tristan Mullis?
Correct.
So did you have any firsthand knowledge about how Ms. Mullis's body was found?
No, I did not talk to Todd or Tristan.
Nope.
Before the autopsy,
Wow.
had you seen any
Here's the-
reenactment of how Ms. Mullis's body was found?
No,
Is it possible you gave Dr. Cruz incorrect information about how the body was found?
I don't believe so. I stated exactly what was described to me by Deputy Thompson.
Can we pull up Thompson's? I want to just give you Exhibit 300 to review, which I believe is Deputy Thompson's report. Can you let me know if that is correct?
Yes,
Would you take a moment to review it and see if this is the information you had when you went to the autopsy?
it is.
And now I'm going to switch to Exhibit 217. Have you seen this before?
Yes,
And for the record, this is also,
What was that?
it's in the exhibits twice, 254, I think, as part of the medical examiner's photographs.
Hi, Robin.
Can you tell us what we're looking at here?
that'd be the inside of the Carhartt coat.
How many arrows are there?
4.
Do you know what the arrows are pointing to?
I believe they were pointing to the holes in the coat.
Okay. Why do they keep flashing it and then getting rid of it? Like, let me see the damn thing. Okay, so this is the inside of the coat. We didn't see this at the first trial. We only saw the outside of the coat. So 1, 2, 3, 4. 1, 2, 3, 4 up here. So there's 4 holes on the inside of the coat.
And for the record, this is also, it's in the exhibits twice, 254, I think,
He
as
really
part of the
liked
medical examiner's.
Yeah. Is it possible that somebody else did these searches on the iPad? Well, it's possible, but it's not probable. Dumb, so dumb, so dumb.
Photographs. Can you tell us what we're looking at here?
That'd be the inside of the Carhartt coat.
How many arrows are there?
4.
Do you know what the arrows are pointing to?
I believe they were pointing to the holes in the coat.
Are you aware of any photographs with arrows from the other items of clothing, the sweatshirt or the t-shirt?
No, whatever photos we have will be maintained in our case file. That's or at the medical examiner's file.
Really, he does comments.
And so this was was this the information you got from Dr. Cruz at the end of the autopsy, that she found 4 holes in the coat,
What do you mean by got from her?
that she told you, that you learned?
Objection, calls for hearsay.
You gotta be kidding me.
That was
Calls for hearsay.
a while ago. I'm not sure. I know there's holes in the coat. I don't remember seeing them take this photograph, but yeah, there was holes in the coat.
Okay. Do you recall testifying previously in 2023 that Dr. Cruz told you there were 6 holes in the coat?
If that was my testimony. Yes.
You would agree with that?
Yes.
And you would agree with me that this photo only demonstrates 4 holes?
There's 4 arrows. The lab techs must have taken that. Yes.
Okay, we can take it down.
Okay, so he
What did you do after the
testified
autopsy?
at a pre-trial hearing, which I don't have. I don't even know if it was ever streamed anywhere. In 2023, that there was 6 holes in the coat. He's the only one that's testified to there being 6 holes in the coat.
In your investigation, not your personal. Okay, we can take it down. What did you do after the autopsy? In your investigation, not your personal life, I'm sorry.
Oh, yes. I made contact with John Turbett and Mike Roffel and just explained to them that this is a potential homicide investigation, and then we proceeded with search warrants and interviews.
Do you recall what activities specifically you did, like which search warrants you drafted or any interviews you did between the autopsy on the 12th and November 16th?
I drafted quite a few search warrants in reference to the farm, seizing electronics, and then we did an assortment of interviews. John and I split up people and performed interviews.
Who were you talking to?
Quite a list. I don't know them all off the top of my head, honestly. I don't know if there's 25 or 30 interviews.
I'm not trying to ask you for specific names, but could you characterize what type of people you were interviewing? Were they other law enforcement or lay witnesses, fact witnesses?
Just essentially, just lay witnesses. We would get information that somebody might know something. We'd go to them. We'd speak to them, and then we would just move on to the next.
Would these include friends or family of Mrs. Mullis?
Yes.
This dude doesn't know what a lay witness is.
Colleagues or coworkers of Mrs. Mullis?
Assortments, yes.
What did you learn, during that time period?
To the 16th?
Yes.
I don't know. I don't recall.
Okay, that's okay. I'm sorry. I don't want you to.
I would have to review my interview summaries. The majority of that time frame, I believe I was preparing search warrants.
Were you reviewing interviews done by other officers or getting updates from them?
I'm sure during that course, yes.
Did you come to any conclusions before November 16th?
I don't remember.
Did you have a suspect November 16th?
When was the autopsy?
The 12th,
With suspects.
on the 16th?
I don't know the dates.
When,
I don't know. I don't remember what we did between the 12th and the 16th. But we would have had two suspects at that point.
who were they?
Would have been Jerry Frazier and Todd Mullis, to my recollection.
So they'd already
And so
ruled
at that
out
point,
full
Rowley was not a suspect. Is that my understanding? Is that right?
I don't know the date that the sheriff had told me about watching the AVL. I'm unaware of the sheriff's conversation with DCI.
If you testified in your 2023 deposition that you let Deputy Rowley know he was clear November 14th, would you accept that?
Yes.
Why was Jerry Frazier a suspect?
I think we established there was communication between Amy and him.
Why was Todd a suspect?
During that time period,
Yes.
I'd have to review my reports on that.
You don't have any recollection or memory?
It came out through witness interviews, like with Terry Stainer. Through the course, we started hearing about relationship problems with Todd. John and I did.
Okay.
And at that point, I don't know the time frame on those, but
Do you recall Todd being interviewed at the sheriff's office on November 16th?
that probably would have been when John Turbid interviewed him. Yes.
Would you have been in the building?
Yes.
Did you listen or watch?
Not the whole time, briefly.
Did you talk with Agent Turbot before the interview?
Yes.
Were you aware that Turbot was going to accuse Todd of murdering Amy?
No.
Have you reviewed any of the recordings from that interview?
It was a long time ago, briefly.
If I tell you that Turbot did accuse Todd of murdering Amy in that interview, would you disagree with me?
I don't know what the context of the interview was.
Do you want me to try to find it and play it for you, or take time to review it?
Are you wanting me to agree to that?
I'm wanting to know if you disagree that Turbot told Todd or accused Todd of murdering Amy November 16th.
I believe that the topic when it came up, I don't know the context of the interview.
Okay.
I don't know exactly what John had spoke to him about.
Okay. And you haven't reviewed Turbot's depositions or trial testimony?
No.
His reports?
No.
If his reports and his audio and the video indicate he accused Mr. Mullis of murdering his wife November 16th,
Then that
would you accept that?
That would be accurate then, yes.
On November 16th, in your investigation, had you obtained any cell phone records of the victim or the suspects?
That I don't know. I forget the date that we actually executed the warrant at the house.
If I told you you executed the warrant after the interview with Mr. Mullis later on November 16th, would you agree?
Yes.
Were you there for that?
For the warrant?
Yes.
Yes.
Was Agent Turbot there?
Yes.
Was Mr. Mullis there?
Yes.
Was his sister Lynn White there?
I don't remember if she was or not. I know Bob Saber was, a few other DCI agents, and a couple other deputies from our office. She may have been there at some point. I don't know.
Okay. Bob Saber, is he an attorney?
Yes.
Did you know he was an attorney when he went to the farm?
Yes, shortly afterwards.
Was he there for Mr. Mullis?
I don't know why I was there. I would assume he was there for Mr. Mullis, yeah.
What did you see as November 16th on that search warrant?
Electronics, and then yes.
And do you recall there being an iPad?
Yes,
And do you recall asking for a password?
I do, yes.
Do you recall testifying about Todd consenting and giving you that password?
Yes.
And Todd consulted with Mr. Sabers and then gave you the password. Is that your recollection?
Yes.
Do you recall testifying at trial that Todd hesitated before giving you the password?
Yes.
Do you think telling a jury that he hesitated had a bad connotation?
Objection, this is, it's an improper question. His opinion on what the impact on the jury was is not relevant.
Sustained. I'll rephrase your honor. What inference were you making when you said Todd hesitated?
I'm going to check again, Your Honor. This is still commenting on what the impact on the jury was. The record speaks for itself. The transcript's already in evidence.
Sustained. Why did you say he hesitated?
Because he hesitated.
Because you talked to his lawyer? That's hesitation? I'm trying to understand your thought process there.
Yeah, so I asked him for the password, and he hesitated, and then he consulted with his attorney. And then he gave me the password.
And you were wearing your body camera at that time?
Yes, it's documented by video.
Do you recall testifying at the criminal trial in 2019 about the results of examinations on this electronic evidence that you seized?
Yes,
And you're not certified to conduct electronic device analysis?
the physical extractions, the digital imaging of a device, no.
And do you have any specific training on interpreting extractions?
For a Cellbrite, we are provided a Cellbrite reader, and we don't need to have a certification on that. The platform is very easily navigatable, and you can't alter it. So no law enforcement has to have certification on the reader program that we are provided from we would use the word Rowley, and he's certified on Cellbrite, so he would do the examination on the examiner, and then he provides the reader program to law enforcement.
Okay, but my question was, do you have any specific training on interpreting the extraction results?
On the reader?
Yes.
No, there is none.
Okay. There's no training available to you?
Not that I'm aware of, no.
Okay. Did you testify that the Google searches were all done by Todd Mullis?
Come on.
I'm going to object. The transcript speaks for itself.
Yeah, because he did.
I don't remember exactly what my transcript, I didn't go over trial transcript, but is it possible that more than Todd searched on that iPad? Yeah, it's possible. In certain categories, it's possible.
Go ahead and say it. Say it.
But it's not reasonable in some other categories of that search.
In addition to Ward Crawley, do you recall also speaking with Roman Gamble at DCI?
Yes,
Did that happen in 2024
it did.
during this post-conviction,
It did.
after you learned about Mr. Castle's examination and analysis?
I don't know what his analysis is.
You haven't reviewed that?
No.
You have reviewed parts of the post-conviction filing, though.
What do you mean by the filing?
Well, in your 2023 deposition in this post-conviction,
Just a few paragraphs. There was, to my knowledge, there was several filings, but I've only read a few paragraphs.
thank you for that clarification. Your deposition made it sound like you read everything.
No.
Were you aware that the iPad did not have cellular data in 2018?
Upon the time that we seized the iPad, I didn't know. I know the iPad is either cellular or Wi-Fi capable. I just seized the device and then gave it to Ward Crawley.
I'm not trying to be flippant, but if a device like an iPad or a cell phone does not have cellular data, does it work in a rural area like a cornfield?
Only
the
if there's
sheriff.
Wi-Fi available.
Is there generally Wi-Fi?
He got promoted from deputy to sheriff. He testified at the trial 2019 like an idiot, and they promoted him to sheriff. He is the sheriff of Delaware County, Iowa. Beware, folks.
Available in a cornfield?
Well, I mean, it depends. We're not going to get far-fetched on this, but there are farms that have Wi-Fi capabilities that extend beyond the house or a residence. Yes, that is possible. Anything is possible. In a cornfield, it depends on how close you are to other residents. This is a hypothetical, but yes.
Did you do any investigation into where Todd Mullis was at the time you thought these searches were being done?
There's no way to know where he was. No,
Didn't you also seize his cell phone?
I didn't.
Didn't you also have it examined and analyzed?
Yes.
Are you aware of cell tower records from cell phones?
Yes.
Are you saying you couldn't have used those to determine where Todd was?
I had asked Ward Crawley about that for the Cellbrite, about the location data, and he didn't provide me with anything.
Could you have talked to witnesses about the dates in question and if they had seen Todd that day?
Yeah, I guess we could. Yeah, we could. Yeah, we could have.
Coming from a farming community, are you familiar with the time period that farmers are most busy?
Yes.
When is that?
Well, weather dependent, spring and fall.
And have you ever seen someone in a field late into the night,
Yes.
early in the morning,
Yes.
around the clock,
I haven't seen somebody in the field 24 hours personally.
but at any time of the day?
Yeah, anytime of the day is possible. Correct.
And spring would be planting season, is that fair?
Yes.
Is fall harvest?
Yes.
Some of the searches that you attributed to Todd would have been occurring in spring or fall, right?
Yes. Some of them were in May and then some were in January.
Did you do any investigation into Todd's activities in May or January? Or what was the other month you said? I'm sorry.
May, well, there's several sections like Roman Gamble, he created a spreadsheet for the layout, so it's easily read for visually.
Did you do any investigation as to those time periods where Todd was?
I don't believe so.
Did you talk to any witnesses
Matter.
about Todd's activities?
Objection, that's totally wrong.
I'm sorry. Your Honor, if I finish my thought. During those time periods of the Google searches.
I don't believe so. I don't believe so.
Do you have any information from your investigation that Todd would have been able to do a search from the iPad while he was planting corn?
No.
Your
Yeah.
testimony at the 2019 trial regarding the Google search warrant return and the iPad, all of that comes from Ward Crowley's work.
Oh.
Am I understanding that?
What do you mean by that?
You testified about the timing and the content of the searches and what they were done on. Do you remember that?
Yes.
And you told us that you were wrong about what UTC time was.
Yes, I didn't understand the time.
And so you testified that some searches were done late at night, but that wasn't true.
Well, correct. It wouldn't have been accurate because the conversion wasn't completed.
And you testified about looking at the iPad and the browser search history.
Yes, Gordon and I did.
That is not the same as a forensic digital extraction, though. Is it the same?
Then what are you comparing it to?
What you did to the iPad?
What Gordon and I sat down and went through as
No.
far as the comparison?
Nope, that's one thing, right?
Okay, that's the device.
And then you personally looked at the iPad in your hands,
Okay.
just like you would for your teenager to
Okay.
see what they've been Googling, right?
Oh, sure. Yes.
You did that.
I looked at when we were down there, we looked into not the search history. It would have been like the Google bar where it says your last 10 or 11 searches, but those displayed on the Cellbrite extraction.
Okay. I think I'm good.
Yes, great. Yes.
Have you listened to the 911 call from November 10th, 2018?
Yes. It's been a while.
Happy.
Yes.
Do you recall when you first listened to it?
I don't.
Would it have been before you arrested Todd?
I don't believe I listened to that. It was thrown into the case file. I don't believe I listened to the 911 call before we made the arrest.
Okay. And you arrested Todd several months after Amy's death.
Yes.
Do you recall the date?
I don't.
If I told you that your body cam reflects February 29th, 2019, would you agree?
Yes.
February 28th, I'm sorry. February doesn't usually have 29 days, right?
Yes.
Did you arrest Todd at his home at his farm?
No.
Where did you arrest Todd at?
It'd be a hog building on 270th Avenue.
How did you know that's where Todd was?
It was a lucky guess. We've seen his truck there.
Okay. And did Todd resist?
No.
When you approached the hog building, do you recall what you said to Todd?
I had opened the door and Todd was sitting there, and then I asked him to come outside.
Do you recall telling him, I have your electronic devices to return to you?
Yes.
Were you carrying a box?
Yes.
Was that in fact a lie?
Objection to that characterization.
Overruled.
There was no electronics in the box. It was a safety precaution.
So the box was empty?
Yes.
When Todd came out of the building, what did you do?
I believe I placed him under arrest.
Did you place handcuffs on him?
Yes.
And then what happened?
Then he was escorted to Eric Brooks' squad car and placed inside.
When you say squad car, does that also include a truck?
It was a truck, yes.
Is it common for your sheriff's office to have trucks instead of a four-door sedan?
Yeah, it was a crew cab Dodge.
And was Agent Turbin on the scene with you?
He was in the truck.
And so you placed Mr. Mullis under arrest and then placed him in the truck with Agent Turbin?
Yes.
What was your plan for having Mr. Mullis with Agent Turbin
John wanted to speak with him again.
after he was arrested?
Yes.
At the time you arrested Todd in February of 2019, you knew he had counsel. Did you?
Well, Bob Sabers. Yes.
Did you coordinate with Bob Sabers so that Mr. Mullis could have turned himself in?
I didn't.
Do you remember discussing that with your investigative team?
I don't believe so. It may have came up. I don't know. I don't remember. It was a long time ago, but as far as I know, no.
Did you consider yourself to be the lead investigator for the sheriff's office?
Yeah. So I'm the lead point of contact for the sheriff's office, and John is the lead point of contact for DCI. And so the two of us, we team together for the lead point of contact. Yes.
Could you have contacted Mr. Sabers and asked him to have his client turn himself in?
Yes, that is possible.
After Todd's arrest, did you read him any Miranda warnings?
I did not.
Did you hear anybody read him Miranda warnings?
No.
You knew Agent Turbo was planning to talk to him in the
Yes.
car?
Yes.
And I've seen this video, so it appears that you leave the truck and go back to the hog barn. Is that your recollection?
Yeah. I think we just stand around outside.
Did you get into the truck at any point?
No.
At the time you arrested Todd, had you listened to the 911 call?
I don't believe so.
Had you listened to the dispatch recordings?
I don't believe so.
Have you listened to them now?
It's been a while, but yes, it was around trial time.
And that would have been September of 2019.
Yes.
Do you recall specifically listening to the 911 call and to the dispatch, like radio traffic?
Yes, that's what we would have had. Yes.
I ask because for me, they're two separate recordings and files. Or do they appear that way to you?
Yeah, I believe it's all one, just the 911 recording with audio, but yes.
So I have you ever listened to a separate recording that's the dispatchers?
2 audio files.
Is it always just been one file?
I believe so.
I don't want to play the wrong thing for you. Do you recall the prosecutor from the AG's office at the trial in 2019, who that was?
Yes, Maureen.
What was her last name?
I believe Hughes.
Had you worked with her before?
No.
Have you worked with her since?
No.
Do you know if she's still in Iowa?
Last I heard, I think she's in Tennessee. I don't know if that's accurate, to be honest.
Did you assist her in preparation for trial?
Well, I didn't assist her. I mean, we trial prepped.
Did you help her with evidence and exhibits?
Yes.
Specifically the 911 call?
Yes.
Do you recall calling her the night before Todd's cross-exam at the criminal trial?
Yes.
Was that after 10 p.m.?
Probably was. I don't know the time, but yes, I talked to her.
Was that about the 911 call?
Yes.
Were you excited?
I don't know if I was excited. I mean, what do you mean by excited? No, we talked about the 911 call. And we discussed if she was going to use a 911 call. That was the conversation.
Did you learn something new that prompted that phone call?
About
About the 911 call?
Yeah. Well, about what the contents of it, whether it said one thing or the other. Yeah, that's what was this discussion about. Yes.
Where did you learn that?
I don't remember how we got that information, honestly.
Did you document any report about how you got that information?
I did not know.
Do you recall the name of the person?
No, I don't know if somebody sent me a message or called me. I don't remember that, but essentially it was a tip.
And this tip tells you there's something else being said on this 911 call?
Yes.
Had you ever heard that before?
I've never listened to the audio before that.
So you're near the end of a murder trial and you never listened to the 911 audio before?
I did not listen to it. We obtained it, we put it in the case file, but I don't believe I ever listened to it.
Because none of it mattered. They'd already decided that it was a homicide, that somebody had gone into the red barn and swung the corn rake at her, killed her, and then they determined it was Todd. None of the other stuff mattered to them. They didn't need to do anything else. Because Kelly Cruz says it is irrelevant because she's already determined it was a homicide by another person. Another person killed her. That's it. That's all they cared about. He didn't even listen to the 911 call. So I'm wondering, because when we were doing the trial, people were saying that it was a podcaster who actually tipped in this 911 audio where he supposedly says, "Die, you cheating whore." That a podcaster had actually heard it and they sent it in. So now he's saying it was just a tip. It was just a tip, guys. Don't worry about it.
Do you know if anyone else listened to it before trial?
Actually, false or speculation.
That I don't know.
Did you have any discussions about the 911 call being an exhibit at trial?
It was an exhibit.
Do you recall talking to the county attorney about it?
About entering it as an exhibit?
Yes.
I think that's common practice.
Are you aware that any statement made by a criminal defendant has to be disclosed to him before trial?
Objection, this witness's knowledge of the rules of criminal procedure is not relevant to the things at issue.
I would say he's trained on those and he knows what Miranda is, so he can answer the question.
Overruled. The witness can answer if he knows.
I don't know.
Do you think it would be important evidence if the defendant or suspect made an admission?
But yeah, I think that's important, yeah.
Do you think the statements that the AG argued Mr. Mullis made are prejudicial?
That wasn't my decision.
I'm asking for your opinion.
Prejudicial? I don't know.
Do you think they were indicative of guilt?
Ooh.
As far as the content,
Well, the new statements that you guys discovered in the middle of trial, were those important to you?
they're important to the case
Why?
because of the content.
Because why?
I'm not quite sure what you're asking me. The content, the Maureen pointed out the audio and she made the argument. I had no involvement in that. So whatever the content is the content is.
As an investigator,
Okay.
disparaging comments about a victim, are those important to you?
From a defendant, yes.
Or from a suspect?
Yes.
Your Honor, I don't think I have any choice but to play it. And if we're okay, we haven't tested audio yet to make sure it works. The 911 call is Exhibit 293.
And 293 has not been admitted.
And so I have to put both of the files in the folder. I was just hoping that you have any
The 911 calls in evidence, so I have no objection. It was admitted into the underlying file, so it's already in evidence in this case.
So I guess 293 will be admitted separately then if it is identified. Obviously, it is part of the underlying record as well.
And I would just clarify for that, as long as this is the same version and file as the, so as long as they agree to that, it's not a different version, I have no objection.
We don't want a new enhanced audio argument, I hope.
I hope.
And then
Your Honor, would you prefer to take a break and we can play it for the state and make sure there's no problem with it?
that might be the safer bet. Why don't we go ahead and do that? And then also any audio recordings will not be reported, just to clarify that. So let's go ahead and take about 15 minutes.
Yes,
We'll pick back
please.
up around 10:30. Courts and recess
Yes.
till then.
Yes, they were both deputies at the time. Yes. 100. Yeah, the guy she cheated with, his coworkers are the ones that are investigating her death. And they hid his name. They would not tell anybody who he was in the first trial whatsoever. They just kept saying that she had an affair with somebody who used to come into her work all the time. They would not say that it was the flippin' deputy. A couple locals came into some Facebook groups and said it was, but this is the first, as far as I'm aware, actual confirmation on record. All right.
Actual audio files in a folder. There might be a third one that is a duplicate of 297, so we will clarify that for you later. But at this time, conferred with the state, we are going to play 293.
I don't know if he did any of the investigation himself. He is not in the case file, but they already knew that he'd had an affair. So the sheriff at the time was already looking in. They considered Keith Rowley a person of interest, and so the sheriff was looking into the GPS that was on the police vehicle to make sure that Keith was not in the area of Amy's. So if he investigated it himself, they really did a good job of keeping him out of the case file, as far as I can tell. He can absolutely still influence the investigation because they're all friends with him. Right. I think the dude on the stand definitely slept with Kelly too. You know what? I wouldn't be surprised. They seem to have a very interesting outside of work dynamic.
File 1, which is, these are the two files that were played in the underlying criminal trial.
And Your Honor, as I indicated to Mr. Mullis' counsel that we're going to object to this line of inquiry. We agree that these are the same as the 911 calls that were admitted in evidence at trial, so we have no objection on that front. However, how we anticipate this line of questioning is essentially an attempt to have Sheriff Emiseth try to determine on the spot whether he can hear it over the court speakers in this courtroom, whether these statements that were referenced at the trial. So if that's where we're going, I'm just going to state that we would object to that because his recollection at the time of trial and what was actually heard in that courtroom is what matters.
Your Honor, I can represent to the court that that's not my point.
Okay, well, we'll play the files and see what the questions end up being whenever you're ready.
Okay, and if we would start file 1.
That's terrible. That's terrible. Okay, Keith. Yeah, this is. I hope they don't play the whole thing like this.
Do you know whose voice you're hearing on this recording?
Yes.
Who is it?
Todd.
Mr. Mullis.
Yes.
Do you know who the other voices would be?
No, dispatcher.
A dispatcher.
Yes.
Okay, finish this one.
I'm going to fast forward past this. I'm pretty sure I have the audio files. I'll have to double check. but I'm pretty sure I have both audio files of the 911 call. So you can't even hear it in the courtroom. If you guys want to actually hear the 911 call, I think we all know the general purpose of why it's being played. So the questioning to him is more relevant than what's in the call. Hi, ATS.
That is the end of the first file. And so we will get the second file of 293 pulled up for you. Do you have an understanding of what was happening at the time of this, during this time period of the call?
Sounds like he's in this vehicle.
Do you know what kind of phone Mr. Mullis had?
LG flip phone.
Well, they voted him for sheriff.
For the younger people in the audience, what is a flip phone?
It's a flip phone.
Does it folds together?
Yes.
Does it have speakerphone?
What?
I believe so. I would assume. I don't know that for sure. I do not own a flip phone.
Okay.
This guy's not old
We
enough to
will
go to
pick back
court.
up with the second file. Okay, what time are we? Okay, so we are about 44 seconds into the second file. Did you hear Mr. Mullis say anything?
He's in a white Chevy.
Did you hear anything else? Did you hear him ask the dispatcher a question?
I don't remember actually, if we're being honest. No, I did.
He's not even listening. He's just like, I don't
At that time, what's your understanding of what the dispatchers are telling Mr. Mullis to do?
I think they're instructing him to pull over, and they're going to start administering CPR.
Have you had other instances in Delaware County where people have driven themselves to the hospital?
I'm sure it's possible. Yes, I don't know of anything in particular.
know. People
And
drive themselves to the hospital. It's very vague.
we can back it up. We'll back this up just one more time for you. Maybe you can listen to see if you hear Todd ask anything else. Did you hear that? No? Okay. That's okay. We'll keep playing. Did you hear Todd say anything there?
I can't understand what it says. Something about closer, maybe?
Okay.
This guy can't understand the stuff that's actually clear in the audio, but he wants the world to believe that Todd in the background was saying, "Die, you cheating whore."
Do you know what's happening now in Todd's vehicle?
I believe he's performing CPR.
Do you,
Would be my guess.
do you,
Your Honor, can I briefly evaluate a witness for the purpose of an objection? Very briefly.
Go ahead.
Sheriff Hemeseth, were you on this 911 call?
No,
Were
Oh, Jesus.
you with Mr. Mullis while this was occurring?
no.
Your Honor, I'm going to object that this is calling for speculation, and it's asking for the witness to opine to what is said and what is occurring on matters that he was not personally present for. He has no personal knowledge of it.
Okay, what the fuck? They had Todd on the stand at trial, and Todd says that is not what he said, and that the prosecution is misrepresenting what he said. And And that is okay because Todd was part of the 911 call, but Todd's telling you that's not what happened. But this guy who gets this quote unquote tip and then tells the prosecutor about it during trial believes that that is what is being said, this die you cheating whore. But even though he wasn't there, he wasn't with Todd, and all of that was fine for the first trial. And now this fucking, 10-year-old wants to come in and say, no, I'm sorry, he wasn't there. He wasn't with Todd. So he shouldn't be able to testify to it. You fucking kidding me?
As to the trivia questions of what's said and when, I don't see how it's relevant. The court already has the 911 call in evidence. It already came out at trial what was or was not said, and that was a weight question for the jury. So Sheriff Hemes's belief based on this sound system, what he is or is not hearing and what occurred is not relevant, and it's not helpful in the state's opinion to the court's ability to determine the facts at issue.
Well, I would agree that I'm having a hard time figuring out the relevance at this point.
I can move forward, Your Honor, if you'd like, and skip ahead.
Go to the relevance.
Okay,
Okay.
thank you.
Mr. Hemeseth, in your review of the other deputies' actions in this investigation, did you become aware that other deputies responded to this 911 call?
Yes,
Do you know if that was Luke Thompson?
it was.
And if I can fast forward to timestamp 6:20, have you known Mr. Thompson for a period of time?
Yes,
Will you be able to recognize his voice?
yes.
Okay, are we at 6:20? Okay, so my understanding, this is file 2 of 293, time code 6:20. Do you hear Deputy Thompson?
Can you replay it?
Yes. Right there, did you hear?
I don't know what that is.
Okay.
That's very hard to hear.
Are you aware that Deputy Thompson arrived at the scene and started CPR?
He did.
And he took over for Mr. Mullis?
Yes, that's what his report said, yes.
Do you hear another male voice on the,
I don't know what that is.
Yeah.
I can't make it out from here, honestly.
is it possible that that's Deputy
It
Thompson
is possible, yes.
and that he's there at minute 6:20?
Yes, that's possible.
That's when they're saying that Todd's saying, die, you cheating whore. And he's saying he can't hear it. Maybe because of the system in the courtroom. I don't know. I mean, it's obviously coming across on our speakers really poorly. But
Do you recall at what point of this 911 call the tip said the statements were?
I don't.
If I directed you to the trial transcript, which is marked as Exhibit 351, which should be Volume 5, page 89. I did not write down the line number.
I have to admit here, like the smiling is really kind of, I don't know, it's unnerving. I don't know why there's so much weird smiling.
Sorry. 89. if I represented to you that in the transcripts, Maureen Hughes stops the 911 call at minute 6:53 of the second tape, would you disagree?
I would agree with that, if that's what that reflects.
Okay. And then again, she stops it at minute 7:00.
Yes.
I'm going to object. The transcript speaks for itself. Sheriff Hemeseth wasn't the one testifying, and the transcript's already in evidence.
Just have one follow-up question.
Overruled. Go ahead.
Mr. Hemeseth,
She's getting irritated with this
would
attorney.
these statements that you called Maureen Hughes about have occurred after Deputy Thompson arrived?
Objection. This is, it calls for speculation. I don't think it's been established that Deputy Thompson for sure did arrive at 6:20. I believe the sheriff's testimony was it was possible.
Well, yeah, I'm not sure that's really an evidentiary objection, but the witness can answer if he's able.
I don't know what you're asking.
If Deputy Thompson arrived at minute 6:20 and the alleged statements that Mr. Mullis makes on the 911 call are at 6:53, wouldn't Deputy Thompson have been present for them?
I don't know if that's when he arrived or not, so I don't know.
If he did, though. If I have a record, his patrol log, if I have another record that shows he's there at minute 6:20 of that 911 call or his testimony, he would be there at the time the tip said Mr. Mullis made other statements.
I don't know.
Not really back
Just have
then.
one more clip to play, Your Honor. What's the timestamp on this one, Gina? This will be at timestamp 6:40 of the second file. Do you know what or who is talking there?
I believe it sounds like Todd. I don't know.
Do you know what he said?
I don't know. It's hard to hear on this.
Do you want her on the ground?
Objection leading.
Overruled.
I didn't understand what it sounded like.
Okay.
Didn't understand what it sounded like.
Did you do anything else? Did you do anything else after you got that tip to see if anyone else had heard those statements during the 911 call?
No, I just told Maureen about it, and then that was her decision.
Okay, and you were an investigator at the time, though, of trial in 2019?
Yes.
And you didn't ask Thompson or Holub if they heard those statements?
I don't believe so, no.
Did you ask the dispatchers?
No.
Did you review Thompson or Holub's reports about the 911 call?
I reviewed the reports.
Does those reports contain anything referencing a statement Todd made?
No.
Did you talk to any of the emergency first responders?
No.
Did you review any of their reports?
No.
Okay. I'd like to move on and talk a little bit about some 2023 activities. You testified earlier that you reviewed the coat of Mrs. Mullis in the evidence room.
Yes.
And do you recall reaching out to Dr. Cruz about the coat and how many holes were in it?
I do.
We're going to pull up Exhibit 230. I believe you saw these during your 2023 deposition. And do you remember if you reached out to her with a phone call or text message or an email? We can scroll through these because I think there's a few here.
Oh, okay. So here's the text messages. This is crazy that they got these text messages. Did you do anything on this case? Also, no. Yeah, he didn't look at anything. Didn't matter. Just gave it to the AG and said, "Here you go." I'm so far behind because my souvenirs can't manage to secure their dogs. Aww. Okay, I can't believe they have these.
Do these appear to be text messages between you and Kelly Cruz?
Yes.
Why are you texting her?
I texted her because I read that report, the opinion report that stated there was 4 holes in the coat, and it's been a while since I reviewed the case file, so that's the original. It's been a while since I've seen it, but that was the main topic about asking her if she was aware of that, how many holes were in the coat. And that's why I went and reviewed the coat, because I thought that was not true.
It looks like in these text messages you took additional pictures of the coat,
Yes.
and then you texted them to Dr. Cruz?
Yes.
You and Dr. Cruz discuss other things?
As far as what, I haven't reviewed this one, but I believe so.
Did you also send her a video regarding this case?
It wasn't directly for this case. It was another individual that's very interested in this case, but it had nothing to do with this case. It was a simulation of a chemical tote, and an individual that I think you know who that is simulating falling into it. Yes.
What? He does not have
do you want to scroll down to page 6 of this exhibit and have you review that message for me? Do you know if you are the blue bubbles or the ones that appear to be gray or white?
Well, see, so he is going to be white. No medical background or common sense, and he can convince others to follow him, and he thinks he's right, and when asked about anything, he has no idea. He just totally doxed his license plate too. Whoever this is that they're talking about. I don't know anything about this situation on this other person who is interested in the case with chemical totes. I have no background on any of that, so this is all new to me. And then she responds, he had to have a serious mental health issue. Travis responds with, yup. She says, do you have his whole license plate? We can't find him now and think he is hiding at DIVVCC, something like that. Travis says, what's he driving? With the license plate, red GMC pickup. If that's what he's in. She says, yes. Thank you.
I think I'm the white.
You think you're the white?
You are the white.
And what do you recall you and Dr. Cruz are discussing? It's this other person, this other video?
Yeah. He was.
And so the blue bubble, you believe that?
This is him and Kelly Cruz, the forensic pathologist.
That's Dr. Cruz's message. So the blue bubble, you believe that's Dr. Cruz's message?
Your Honor, I'm going to object on relevance on this line of questioning. This text string that we're currently discussing, this portion of it is related to an individual who is not, as we've discussed in chambers and during sidebars, is not directly related to this post-conviction relief action, is an interested member of the public who has taken a very strong interest in the case, and the discussion pertaining to that individual is not relevant to the facts that the court needs to determine here.
Yeah. Can you help me understand why this would be relevant under a PCR analysis?
If I could ask maybe 2 more questions, I think it'll be clear.
Go ahead.
Oh, she's so
Mr.
irritated.
Nessa, the individual that created the video or that you sent to Kelly Cruz, did he have opinions about Todd Mullis' guilt or how Amy Mullis died?
Oh, yes.
Did he disagree with Dr. Cruz and you?
Yes.
Do you then go on to discuss and agree with Dr. Cruz that he must have a mental illness?
Objection, relevance. Again, this is not pertinent to the facts of the issues before the court.
Sustained.
Yeah.
If we continue on in your messages, down to, sorry.
I don't know who that's about.
It's the first one with the color. Is this the message where you send her pictures of the red Carhartt coat?
Yes.
Pink, I'm sorry. And then the next page contained 2 more images. And then what did you write?
I'm struggling that this attorney can't seem to represent to the court the relevance of what she's trying to get in. I don't know why. She's like, well, just let me ask the 2 questions. And it's like, well, no, just tell the judge why it's relevant. Tell her why it's relevant and why you want to continue. Because now you asked your 2 questions, showed no relevancy, and she now stops an entire line of questioning, which it probably could have actually been very relevant, that there's this relationship between these 2 individuals discussing the case years later during post-conviction relief.
I don't know, I don't see it.
I believe the text is in between the images.
Oh, sorry, 5 holes.
5
Were you
holes.
referring to the code?
Yes.
Did you have documentations in your reports anywhere else about the holes in the code?
I did not.
Did you have Dr. Cruz's photos that we looked at earlier with the arrows?
At that time, yes.
Okay, and then scroll to the next page, page 9.
So now we're saying there's 5 holes. Kelly Cruz says there's 4 holes at time of autopsy. He testifies before and says there was 6 holes. Now he's sending her in a text message that there's 5 holes. Right, man. I don't know. I don't know.
You also, so an article is sent. Do you know if you're sending that or Dr. Cruz is sending that?
I believe that'd be her.
And then the next page, page 10, are you guys discussing the article?
Mullis attorney. Hold on. I'm going to see if I can pull up this article. Mullis attorney reveals alleged mistakes of the medical examiner on the case. Oh wait, I think this is a change. This is a change.org. Let me see. Mullis attorney reveals alleged mistakes of the medical examiner on the case. Let me bring it over here for you guys. April 18th, 2023. Mullis attorney reveals alleged mistakes of the medical examiner on the case. Take a look at the news story just released. Finally, the truth comes out. Sign this petition. Okay, let's see. Okay, so this must be the article. Yeah, this is the article. Okay, that's why that popped up, because they added the article. Where's the article? Oh, is that just a video? What the hell?
Now to this, some new evidence is calling into question the facts of the case against Todd Mullis, including whether his wife was even murdered in the first place. In 2019, Mullis was convicted of killing his wife with a corn rake. His attorneys filed a post-conviction relief request for Mullis this month. Max Tedford spoke with Mullis's attorneys about the alleged new facts of the case, and he joins us live now with more on this. Max.
Well, Mullis's attorneys say this was a farm place accident. The medical examiner made serious mistakes in ruling it a murder, and they say they have experts with decades of experience backing this analysis where the medical examiner did not.
Wound paths, using the appropriate panels of toxicology testing, the one of the most basic things you would think would happen that she failed to do. She literally came to the opinion of this being a homicide within a matter of a couple of hours.
Dina Neshwant-Rowley says they had 2 forensic pathologists and a biomechanical engineer take part in their investigation. The 3 experts have decades of experience each, and in each of their reports, they criticize what they consider missteps by Dr. Kelly Cruz, the medical examiner on the case.
Without having the deceased medical records, which is standard protocol, so she could see, well, what medications was this, patient on before she makes this final determination that's so crucial.
In their reports, they point out Cruz only had 4 months of experience on the job when she got involved, citing her inexperience as a reason why so many mistakes were made. but they say her biggest error was never visiting the scene. The hallway in the shed where the alleged murder happened is about 2 feet wide, which is even smaller than where I am now. And Dr. Cruz alleges Mullis, who's over 6 feet tall, was able to swing this corn rake underhanded several times, killing his wife. The defense's experts say that doesn't make sense, instead alleging Amy fainted and fell back first onto the corn rake, spines up.
There's only 4 holes in her coat. How do you stab someone 2, possibly 3 times when there's only 4 holes in her coat that nobody ever looked at and they should have looked at?
The experts state in their report that what likely happened is after Amy Mullis fainted and fell onto the rake, the pain woke her back up. In her struggle to get it off, the spines were able to stab into her 2 more times before she passed out. With that struggle making her internal injuries worse, Rowley's experts believe that is what killed Amy Mullis. Rowley says they submitted this evidence to the Iowa Medical Examiner's office over a month ago for them to review.
To give them an opportunity to review the reports, to look at the analysis, to look at the science behind it. But unfortunately, and for reasons I can't explain, that they refuse to look at the reports. They refuse to change anything.
Now, I reached out to the medical examiner's office today to find out why, but I haven't heard back. However, Rowley says that her experts' reports are available at any time when the medical examiner's office wants to look at them. Live in Dubuque, Max Ted for News 7, KBUM.
Some very interesting developments there. Thanks, Max. And with this being a post-conviction relief request, it could go to a new trial, but the judge could also choose to just drop the case, or something in between could happen. We won't know for sure until we hear the judge's answer in the next few weeks.
Okay, so now back to the text messages. So Kelly Cruz sends this article to the sheriff and says, "How rude." And he says, "This is out of control." She said, "They're obviously desperate, but it's just infuriating. Oh, it's just so infuriating." And he says, "Yes, I agree." She said, "Do you think it will take a long time for the judge to make their decision?" And he says, "Probably." Reporting live on the scene from the hallway outside of my office. Dun, dun, dun. Okay, and there's still more, but I don't know if they're going to show us everything. So hopefully I get these in my Foya request. But we'll see. Blowing it up.
Your Honor, I'm going to object again. Sheriff Hennesseth's and Dr. Cruz's opinions about the media presentations and the filings by Mr. Mullis's counsel are not probative on any issue that is before the court for determination. They are free to have personal opinions in their lives about how they feel the process is going, but it's not relevant for this proceeding.
Any response, counsel? Your Honor, I think it's relevant for a couple of reasons. One, I haven't been able to fully ask yet, but Mr. Hennesseth has done several media interviews regarding the case. The messages are illustrative of his attitude and towards the post-conviction and the actions he's taking after the filing.
I will allow a few very brief further questions on this topic, and then I think we need to move on.
Yes.
Again, this is a PCR bench trial. There is no jury here. Let's remember that and keep to the relevant, important issues.
Yes, Your Honor. Mr. Hennesseth, did you and Dr. Cruz then discuss the PCR?
None. What do you mean by discuss?
In these messages, are you discussing the post-conviction filing?
I believe she asked me a question about it.
You say this is out of control. Are you referring to the post-conviction filing?
I can't remember what that was in relation to.
Okay. Were you open to receiving new information about how Amy Mullis had died?
Yes, always.
But you didn't read the entire post-conviction filing?
I did not.
You also spoke to Dr. Cruz on the phone during or after the post-conviction was filed. Did you?
I believe that's possible. Yeah, I don't remember the dates and times I actually called her.
So again, just like Kelly says, they're open to new information, yet neither one of them will actually read the new information.
Did you say in these messages that the experts got it wrong?
Yes.
think that's the very last page, page 11. Sorry, I'm used to you being able to flip through your own exhibit, so my fault.
Okay, so here he says, probably they are attacking my for sheriff page now, LOL, with fake accounts. There has to be a hearing and everything. They are trying to taint the jury pool. That's all they are doing. They even got the number of holes in the jacket wrong. He got the number of holes in the jacket wrong. But okay. She says, really? That's absolutely ridiculous. And then she says, I know. I'm glad you have the opportunity to tell the truth then. She says, I had no idea it was such a big to-do. I thought they already presented their argument to the judge. Can't wait for them to say more obnoxious things about me. He says, LOL, join the club. They say a lot about everyone, and it's dumb. It's dumb.
Did you say the experts got it wrong? Someone got it wrong?
Oh, I already answered that, yes.
Oh, I'm sorry. Okay, we can take that one down.
Come on, lady.
If the medical examiner's office missed something and were wrong that Amy Mullis' death is a homicide, would that change your investigation?
Well, it would depend on what they miss. That's a pretty broad question.
If she's wrong and it's not a homicide, does the rest of your investigation prove murder?
I believe it does.
Are you relying on the electronic evidence?
Everything else in a whole.
What else is there besides electronic evidence?
Other witness statements. I guess I haven't reviewed any of the other depositions of witness statements, so I'm not up on all that.
Okay.
But I know there was a lot of witnesses called, and there's a lot of elements to this case.
Are you aware of any evidence that Todd Mullis killed his wife Amy besides what was presented at trial?
No.
I know we talked briefly earlier, I think before the break, that you talked to Roman Gamble at DCI.
Yes.
Can you tell me briefly who he is and why?
He's an intel analyst.
Do you know if Lord Crawley retired from DCI?
Yes.
What did you ask Roman Gamble to do in 2024?
I asked him to take the cell right extraction and the Google searches and to combine the search history so as an easier workflow document for visual aid.
And did you do that because your testimony at trial was being challenged in this post-conviction?
Well, I never had that formal document made. That document is what Ward and I and Scott Rieger talked about. We never had it officially drafted, so I had Gamble create that document, merge the two searches.
So you found that what you had from before wasn't sufficient, you needed something else? Am I understanding that?
No, that's not accurate. It was sufficient, just a better workflow product.
Okay, nothing further.
It was not.
Cross-examination?
Thank you, Your Honor. Good morning still. Sheriff Hemseth, how are you?
Good.
Just want to ask some follow-up questions so we're on the same page here. And I'd like to
I feel like she missed so many opportunities. I feel like there were so many more opportunities there with that testimony.
start with the Google search document that we were just talking about with Mr. Gamble. You did a deposition in this post-conviction relief action in 2023, is that right?
Yes.
And at that point, it had been approximately 5 years since the investigation had occurred, is that right?
Yes.
And it had been several years since even the trial had happened?
Yes.
At your deposition, you were asked various questions, and your deposition's in evidence, of course, but you were asked various questions about the Google searches and how you came to certain conclusions at trial. Do you recall that?
Yes.
Was part of the purpose for creating this document with Mr. Gamble, was that to help refresh your memory of how you came to certain conclusions?
Yes.
And that was given the passive time, things like that?
Yes, create a better workflow document for visual aid.
You were asked some questions about completing reports in this case. Did you complete any reports in this case?
Yes.
And did you document portions of your interviews and investigation that you thought were important?
Yes.
But you didn't document every single action you took, everywhere you drove, is that right?
No.
Is that typical in an investigation to not document every single thing you do on a day-to-day basis?
Yes.
There was some testimony where you referenced that you didn't have access to reports prior to your testimony today. Is that in part because your case file, your reports, your evidence were provided to the state, the prosecution team as part of this post-conviction relief action?
Yes.
So it's not as though that you have somehow had the reports were taken from you for any other reason, right?
Correct.
You were asked a question about your theory on November 10th, 2018. Do you remember those questions?
Yes.
And this call came in from Mr. Mullis and his son as a farm accident initially. Is that right?
Correct.
So the approach to the investigation was reliant initially on that representation?
That's what the deputies had told me, yes.
So was it only after the investigation and the autopsy, those results and information that led you to determine that the investigation pivoted from an accident to a homicide investigation?
Correct.
So any steps you took in those initial hours and days were a result of how it was reported to you. Would that be fair to say?
Yes.
You were asked questions about former Deputy Rowley. Can I clarify, was it your understanding that Sheriff LeClaire, your predecessor, had confirmed via the, I think you called it the AVL system, or the GPS, that Deputy Rowley was nowhere near the Mullis farm?
Correct.
And when you say that Rowley was cleared, you don't recall specifically the exact time frame of when that AVL data was reviewed, do you?
No, I don't.
And the AVL system, the Sheriff LeClaire is the one who reviewed that?
Yes, he's the only one that has access.
But you were aware in the flow of the investigation that Deputy Rowley was confirmed to not be in that area?
Correct.
And for whatever reason, that wasn't preserved, but it doesn't mean it didn't happen, right?
Right.
There were some questions about the autopsy, and you were asked how many holes they found in the coat or clothing. Do you recall that?
Yes.
And you had prior testimony where you were trying to recall how many holes they observed at that time. Do you remember those questions?
Correct.
And you thought it might have, your recollection at the time of your deposition was you thought maybe they had counted 6. Do you remember that?
Correct.
Would it be fair to say that regardless of your memory, that you would defer to the notes and the subsequent viewing of the clothes for what the evidence actually shows?
Yes.
So if the evidence shows there's 5 holes in the clothing, you would defer to what that shows?
Yes.
Regarding
Testimony at first trial was that there's 4 holes, or well, I should say the photos from first trial show that there's 4 holes. Then Hemisath goes in there, looks at the evidence, and now there's 5 holes. But he testified in 2023 at a hearing that there was 6 holes. Okay, no matter whether there's currently 5 and there used to be 4, it's fucking shady, number one. But number 2, it's still not 6. So it still does not deter from the fact that the rake could not have left the clothing for her to be swung upon multiple times.
the Google searches, you were asked some questions about the harvest season and when planting is. And there's some, actually first, let me go to, there was questions about UTC time, which I believe is Universal Time Code. Does that sound right?
Universal Coordinated Time.
Thank you. The purpose of your investigation with the Google searches was not to determine what time the searches were, was it?
No, it was specifically the content.
So that was your focus, was the content of the searches?
Yes.
You were also asked a question about Miranda warnings. And to be clear, you were not in the truck with Agent Turbot and Mr. Mullis, right?
No.
So if Agent Turbot had read Mr. Mullis's Miranda warnings at that time before asking any questions, you wouldn't have been personally aware of that?
I would not have been present.
And the only other person in that vehicle besides those two is a former deputy who is unable to testify for other reasons, right?
I don't know if he was in the vehicle or not, but yeah, you are correct.
And that's because he has passed away?
Correct.
Thank you. I have no further questions. Thank you, Sheriff.
Any redirect?
I think very, very briefly, Your Honor. One quick follow-up, Mr. Hemsath, regarding the Google searches. You just said that you were only concerned about the content of the Google searches.
That was the main focus, is content.
Did you do any investigation to determine who created the searches or did the searches?
No. Don't lie.
What exactly you're asking?
I'm trying to understand that.
Did you do anything to figure out who actually did the fucking search, you moron? God.
That you were investigating the content.
Yes.
Did you do anything to investigate who made the search?
Rowley and I worked on it.
And I just want to know specifically you.
Oh, I don't think I did it. No.
Okay. You didn't talk to other members of the Mullis family about the content that you found?
I did not.
Okay. And we talked earlier about how you didn't do any, did you do any investigation about the times of the searches to determine where the iPad or another device could have been?
No.
Or the people that had access to those devices?
Right.
Okay. Do you recall testifying at this criminal trial that you didn't have any other suspects outside of Mr. Mullis and Mr. Frazier?
I don't remember that.
Okay. Did you mention Deputy Rowley in your trial testimony?
Objection, Your Honor. I believe my recollection is there was a subject of a motion limiting for the trial. Please correct me if I'm wrong, but I believe it was subject of motion limiting to limit the testimony of specifically involving the Deputy Rowley issue. So I don't want Sheriff Hemeseth's testimony to be mischaracterized.
I'm happy to defer to the court on what the transcript says and rephrase my question, if that would be helpful.
That's probably the quickest way to solve the issue. I'm looking at the motion in limine, but.
And sorry, Your Honor, to clarify, motion limiting from the underlying trial.
Oh, okay. Then it would be definitely the quickest way to solve the problem. If you don't mind, Ms. Nichols-Cook, we'll handle it that way.
Mr. Hemeseth, did you testify at the criminal trial about Deputy Rowley's affair with Amy Mullis?
No, I was never asked that.
Were you told not to mention his name because of a motion in limine?
I don't think so.
Don't remember. Okay. Can I just one more, Your Honor?
Certainly.
If I may show you one more exhibit and we'll pull up 371, I just want to confirm that this is the Gamble chart that you were talking about. And I believe Mr. Gamble's going to testify later, but just so that you and I are on the same page. Do you recognize this?
Yes.
We can scroll, I think it's a couple of pages.
Should be like 6,400 searches at the bottom.
Okay, that's a lot of pages. But does this appear to be the document you got back from Mr. Gamble?
Yes.
Okay, and what you were referring to earlier, is that better visual?
Correct.
Okay, we can take that down.
Because he was called out in the trial for not actually comparing the information from the Celebrite dump of the iPad to the Google warrant results of the searches linked to the iPad. And so now he's had this other little document made comparing the two, so that if it gets brought up again during post-conviction relief, he isn't such a fucking idiot. Well, it didn't work out well.
My last question is, are there any other notes or reports that regarding the investigation into Ms. Mullis's death or Todd's arrest that wouldn't be in your file?
Not that I know of.
And did you learn at any time about what happened in the car with Agent Turbot and Mr. Mullis after he was arrested?
I don't believe so.
So you don't have any information about whether Miranda was read at that time?
I do not.
Or what, if any questions were asked?
No.
Okay, nothing further.
Any redirect?
Yes, Your Honor, but I'll
So he didn't read him as Miranda, but he doesn't know if Turbot did.
try to keep it limited to 2 questions, which I'll regret in a moment. Sheriff Hemeseth, we'll try to get you out here in a second, but I just wanted to clarify. So you were discussing your investigation, the Google searches, the cell phones, all of that. Was all of that done with the assistance of other agencies and other investigators?
Yes, multiple.
And so that included, I think you referenced Ward Crawley, who was an ICAC or DCI investigator, DCI agent Scott Rieger, all of those people?
Yes.
So your conclusions about digital evidence was all related to the totality of your investigation working with those other people?
Yes, it was a team effort, yes.
And then final question.
So they're all
testimony
idiots.
here
Great.
at the trial, your depositions, were you truthful to the best of your ability and your recollection of everything given the passage of time?
Yes.
All right, I appreciate it, Sheriff, and I have no further questions.
Anything further, Ms. Nichols-Cook?
One question, Your Honor. Have you filed any supplemental reports to correct your prior testimony at trial?
I don't believe so.
No further questions, Your Honor. I just want to make sure that we have agreement on the exhibits before the witness leaves.
Okay. Do you want to confer with Mr. Bakke quickly off the record, or?
Make sure I saw this before 11, the Thompson report at 300, the sheriff over, Thompson's report, do you have a policy included? The dispatch.
So, Your Honor, I think we're in agreement that we would move to admit Exhibit 311, the photographs from the Delaware County Sheriff's Office, to formally move to admit 300, Deputy Thompson's report. And then Exhibit 400, the policies of the Delaware County Sheriff's Office, we would ask for the caveat that they be filed at a level 1. And then Exhibit 297, which is the dispatch audio recording, we did not play that this morning, but we would move to admit it upon agreement for completeness for the record.
Mr. Bucky, any objection to?
Amanda, I like the judge. She's really no nonsense. I mean, the crazy thing about this judge is she's given up a lot of time to hear this. So I just and I think I said this yesterday too, or maybe this morning, I don't remember. It all kind of runs together. But you know, whatever was delivered to her in all the pretrial stuff made her determine that this was necessary. So she sees something there. So I keep going back to that because she could have just said, sorry, nope, not going to happen, essentially like everybody else did. Now, for the most part, I think his attorneys are doing a great job. My bigger concern is the legal requirement or the legal hurdle that they have to get to or get over for her to do something. Now, that's going to be more important to me, but I think she's no nonsense. I think, you know, she's not done anything or said anything I disagree with. The line of questioning with this guy, not relevant to the PCR, because this attorney did not show how it was relevant. I think that there was a lot of missed opportunity from Todd's lawyer on this. And I would have loved to have actually seen Tara be the one who was doing his direct, because Tara's like, she's very quick-witted. I mean, she's very quick, like on the mark. She's listening to words. She hears what's being said, and she responds very clearly. I don't know if this was the right attorney because I feel like I think this could have been a missed opportunity. And it almost feels like with this testimony, the judge feels like it was a waste of her time. And I don't like that, because if she starts to feel like it becomes a waste of her time, then whether consciously or subconsciously, that becomes Todd's fault. I think she probably wrecked him in the depot, which I'm hoping we can get. I'm hoping we can get that. So, you know, I'd be very curious, you know, because some of the depots are submitted to the judge that we didn't get to see. Some, I think we did, and I haven't got to go through everything yet, so I don't know. But I don't know. I feel like she's a good judge. So far, I have no issues with her. I don't have any issues with her. Will she do what I want her to do? I don't know.
Those exhibits.
No, Your Honor, thank you.
Right, they will be admitted. Thank you, Your Honor.
A really good attorney.
Right. Anything further then for this witness, or is the sheriff free to go?
He is free to go.
Thank you, Sheriff.
She doesn't like you guys. He's so tiny.
Are we returning then to Dr. Nye?
We do not have a good place for Dr. Nye to wait in the building. She is nearby. I'm wondering if the court might be amenable to starting our lunch break on the earlier side and reconvening at 1 o'clock or something in that time frame. If not, we can get her, but she's nearby. She's not in the building.
That's fine. We can take our lunch at this time and plan on resuming then at 1 p.m. Court is in recess until then.
Okay. Now Dr. Nye is coming back. Let me pull it back down.
Good afternoon, Dr. Nye.
Good afternoon.
When we left off on your testimony yesterday, we were talking about some of the hypotheses that you considered in your evaluation in this case. Do you remember that testimony?
Yes.
And we had talked about your hypothesis that you considered, which is that the hypothesis that these wounds that we've been talking about and Ms. Mullis's injuries were caused by someone swinging this corn rake into her body. Do you remember those questions in your testimony about those issues?
Yes.
I want to show you, and I've shared these demonstratives with the state, Your Honor. I want to show you, for starters, demonstrative I.
We're gonna get back to start seeing some reenactment.
Can you rotate?
Oh, okay.
Just 90 degrees. Actually, let's start with T. Do you see the figures on image G in front of you, Dr. Nye?
Yes.
And do these figures help you explain your testimony as to why you disprove the hypothesis that someone could not have swung the corn rake into Ms. Mullis's body?
Okay, I'm gonna slow it down even. I'm gonna put it back to normal.
Yes.
Can you explain how these, how demonstrative G illustrates that?
We were talking about an overhead swing. So this demonstrative, even though it's two-dimensional, shows that with an overhead swing, the angle of entry of the tines does not match the diagnosed wound trajectories.
And is that true for those wounds A through D that have one trajectory and those wounds E through F that have another?
It's true for all of the wounds, yes.
All right. I want to also show you another demonstrative K.
Remember, I've not seen any of this yet. This is all fresh to me too.
Do these images also help explain your testimony that you disproved the hypothesis that someone could have swung the corn rake into Ms. Mullis's body?
Yes.
And can you explain how?
Similarly as the other diagrams do, this essentially is showing an overhead swing and in various positions of erect to bending over to lying on the ground.
That photo is really blurry, but so for presentation purposes, it shows they actually have on here how the wound, like how deep the wound is and the direction of the wound internally. So you can see each one labeled in a different color, but it's very hard to see with the blur. So each wound and where it enters and then how deep it is and then the trajectory of it. Okay.
The rake entry of the tines don't match the physical evidence being the wound trajectories.
I want to also show you demonstrative L.
Well, except for comb over.
Does this demonstrative help illustrate your testimony from yesterday that someone could not have swung, that you disproved the hypothesis that someone caused these injuries or could have caused these injuries by swinging the corn rake into Ms. Mullis's body?
Yes, this is in reference to the lateral swing.
And how,
Is dude and the dude with the comb over? I don't know their names. I don't know the prosecutor's names. Is dude and the one with the comb over, Paul? Because he may be a good attorney, but I can't leave the comb over alone.
how does this image illustrate that concept?
Oh, it is?
Swinging it sideways doesn't generate the wound trajectories diagnosed by Dr. Cruz.
One question I wanted to ask you yesterday, and I know that we talked some about different positions with respect to your testimony about this hypothesis. Would it have been possible to create the wound pattern and the wound trajectories that Ms. Mullis had if the person who caused these injuries was sitting or kneeling?
Sitting or kneeling behind them, you mean?
Let's start with that. Would that have been possible?
So looking at the length of the rake and Mrs. Mullis's anthropometrics and the location of the injury, that would not match, no.
And what about if Ms. Mullis were kneeling or sitting? Would that be possible?
Same thing, the angle of entry wouldn't match the wound trajectories.
Thank you. I think we can take that image down. talked yesterday about the hypothesis that one or more of the injuries was caused by someone pushing this rake into Amy Mullis's back. And I wanted to ask you if you considered the hypothesis that someone kicked this rake somehow into Miss Mullis's back to cause these injuries.
I don't recall us talking about the rake being pushed.
All right. Well, let me start by asking you about whether if you consider the hypothesis that someone kicked this rake into Miss Mullis's back.
Yes.
And what did you determine about whether that hypothesis was possible?
That it's unlikely.
And why is that?
As we discussed earlier yesterday, Miss Mullis, based on the wound pattern, the spacing of the wounds, as we discussed, she's hyperextended when the injury occurred.
And you described yesterday hyperextending meaning?
Right, so she's hyperextended, shoulders back, rotated. If someone's on the ground, that is an active position to have to hold. So you'd have to then place the rake in that position, keep the rake there while she doesn't move, and then actively kick it. That is not a feasible hypothesis.
So a second ago, I want to make sure that I spoke correctly. We had talked about the hypothesis that someone pushed Miss Mullis onto the rake. That's what we discussed yesterday. Do you remember that testimony?
Yes.
All right. I do want to discuss with you this other hypothesis, whether someone pushed this rake into Miss Mullis's back, meaning they held the rake and pushed it into her. Did you consider that hypothesis?
Yes.
And were you able to prove or disprove that hypothesis?
I was able to disprove it.
How?
That comes into now, if we give the mechanism of the injury, meaning the rake was in the appropriate position to cause the diagnosed wounds, keeping in mind that she's hyperextended, the rake has to be angled obliquely to her body, and the rake handle is essentially parallel with the long axis of her body. Then you have to consider, as I talked about, magnitude. So I considered magnitude at that point.
Did you, and so what were your conclusions about whether it would be possible to have the magnitude of force necessary to cause those injuries through that mechanism?
There is not enough force with this blunt object to push the rake into Ms. Mullis's body.
How do you know that?
Based on my investigation.
And what about your investigation led you to conclude that?
Biomechanical and scientific literature that talks about the penetration threshold for blunt objects into the body.
And what does that literature say about that topic?
What it says is I need about close to 75 pounds of force for one of these tines to enter the body without the clothing. When you add on the clothing, then we're over, 90 pounds. And then the fact that there's 3 tines going in, then you have to distribute the forces. So you're multiplying that now by 3. There is biomechanical literature that talks about the push force, and there's different kinds of pushing. If you're holding it against a body and you're constantly pushing, or you're actually pushing with acceleration. So if you use the pushing with acceleration, that's a more severe scenario compared with the constant push, because now you're adding acceleration in. The maximum push force by males is about 138 pounds. So that is not enough force to penetrate the clothing and her body.
And again, is that true whether someone is applying the constant pushing that you described or doing the pushing with acceleration?
That is true, because if it doesn't meet the threshold with the acceleration, it's not going to meet it with the constant pushing.
Were you able to determine any hypothesis where a person would be able to push the rake into Miss Mullis's back to cause these injuries?
Sorry, can you say that one more time?
In considering this hypothesis, the hypothesis of whether these injuries were caused by someone pushing the rake into Miss Mullis's back, were you able to envision any scenario where that was possible?
No, because that's already, even with 2 tines, we're not reaching the necessary threshold. So again, I said a very, very conservative minimum. It's greater than that, is 90 pounds. Multiply that by 2 tines, and that's going to be more than 180. And the very maximum push force is less than that.
In the literature that you looked at on this issue, what was the blunt force object that the literature discussed this concept with respect to?
Screwdrivers.
Is that flathead screwdrivers like the screwdrivers we were discussing yesterday?
Yes.
And it was your testimony yesterday that this corn rake is blunter than a flathead screwdriver?
It's blunter than a 1/4 inch wide flathead screwdriver.
And thanks for that clarification. I appreciate that. Did you consider the hypothesis that Ms. Mullis's injuries were caused by Ms. Mullis falling down onto the rake?
Yes.
And could you disprove this hypothesis?
I could not disprove it. Actually, I proved it.
Would looking at a demonstrative assist you in explaining this testimony?
Yes.
All right, I want to show you demonstrative J. Can you explain how it is you determined that you could not disprove the hypothesis that these injuries were caused by Ms. Mullis falling down onto the rake?
So again, we talked about yesterday how lining up the rake with wounds A, B, and C, and D, we know that A, B, and C occurred first from the analysis that I talked about yesterday. So lining up the rake with the rake lying flat on the ground, tines up, if you line up those tines with the wound paths, that demonstrates that when she falls, that this generates the mechanism necessary to cause the injury. So now that I showed mechanism, then I analyzed force.
All right, and I want to get to force in a minute, but just sticking with mechanism for a second. You talked yesterday in your testimony about the concept that if someone had pushed Ms. Mullis, so stood and pushed her onto the rake, there would have been rotational forces that would have sent her at least somewhat in a horizontal direction. Do you remember that testimony?
Yes, it's rotational as well as horizontal velocity.
And thank you. Why wouldn't that concept have prevented Ms. Mullis from falling down onto the rake in the way that you're just describing you could not disprove?
Well, when you have horizontal and rotational acceleration that pushes the body across, basically, if you think about parallel to the floor and rotating about that axis, when you contact the rake, because the rake is top heavy, it's going to flip. In the falling situation, when somebody falls from standing height and falls backwards, her body will contact the tines first, and then her lower body essentially pins the rake down with the rake handle down, which prevents it from flipping.
We're talking about a 4-tined rake and 6 wounds. So this hypothesis requires Ms. Mullis to have fallen on this rake more than once. Isn't that right?
Yes.
How could that have occurred from a type of force and direction of force perspective?
Well, as discussed, the A, B, and C wounds are created first because we've excluded that E and F and D being created first for the reasons we talked about. After A, B, and C are created, if you're, her trying to get up, she could roll to her right. The rake handle prevents her from sitting up straight, so sitting on her buttocks because it's too long, it's longer than her torso. So for her to get up, she'd have to roll over. And if you roll over to your right and not to your left, because otherwise you're rolling over the rake, if you roll over to your right, essentially you're causing tensile loading, and you can pull out that tine 3, which is in wound C, because it's not as deep as A and B. Right? Remember that wound C is 3 and I think 1/2 inches deep. So if you can pull wound tine 3 out of wound C just by attempting to get up and maneuvering, trying to get the rake out of her. The rake stays in the clothes at that point, and in her movement, the rake then moves within the clothes, causing the abrasion above wound D. Even if she gets up onto her hand, she doesn't have to get all the way up to standing, not even to her knees yet, getting up to leaning up on her hand and then falling backwards to get wound D.
I want to stop you right there where you've caused wound D, and I'm going to show you another demonstrative, which is demonstrative F. Does this demonstrative help illustrate your testimony about how Ms. Mullis could have fallen on this rake more than once?
Yes.
And can you explain how it does that?
Yes. So basically, her pulling on the rake handle to try and extract the rake from her body reorients the tines upward. With A and B still in her body, that is then consistent with the tines moving around, as Dr. Hammers discussed yesterday, with the external and internal wound pattern showing that the tines are moving, tines 1 and 2 are moving in wounds A and B. Once you reorient the rake and she falls on it, then you have the mechanism to generate ENF.
From the data that you had from Dr. Cruz and Dr. Hammers about the pattern of wounds A for F, did this hypothesis match?
It matches everything, yes.
And from the depth of the wounds as measured by Dr. Cruz, did this hypothesis match?
Yes, the A and B are deepest, and they stayed within her, and E would be the next deepest.
In terms of the physical characteristics of the rake and the spacing of the rake's tines, does this hypothesis match for all of Ms. Mullis's wounds on wounds A through F?
Yes.
You had talked earlier about Ms. Mullis's clothing. From your investigation and analysis of the clothing, did this hypothesis work?
Yes, with the less holes in the clothes relative to the holes in her body, and understanding that time 3 doesn't come out of the clothing to cause wound D, yes, it all fits.
And from the issue that you were discussing a minute ago of Ms. Mullis's back being hyperextended, at least on the right side, does that fact and that concept, does that fit with this hypothesis?
Yes, even when you move the rake in this position that we see here, you reorient the rake handle down by her left hip, trying to extract it. That'll cause, again, the back skin to basically compress together.
From your review of the layout of the shed and the physical characteristics of the shed, did this hypothesis fit?
Yes.
How?
The small spacing, there's not a lot of room in there. So we talked about that for the swinging scenarios, but there is enough room to fall and refall on this implement.
Were you aware of evidence in the record that there was blood on Ms. Mullis's hand and blood on the handle of the rake?
That's what I reviewed in the records, yes.
And did that information fit with this hypothesis?
That fits with this hypothesis, yes.
How does it?
So she has to grab the handle to reorient the handle in the manner that we see in this figure in order to sustain ENF. So grabbing that handle with blood on her hand would transfer to the handle.
You told us a moment ago that, and I think discussed this yesterday, that first you have to determine the type and the direction of the force to determine if those mechanism issues fit with the hypothesis. And is it your testimony that those factors fit with this hypothesis?
Yes, the type and direction of forces in this fall scenario fits with all the injuries.
All right, and in your method of analysis, you would then go on to determine this question of magnitude, whether there could be enough force here to cause the injuries in this hypothesis. Is that right?
Yes.
So in the hypothesis you've described, we're talking about a couple of different kinds of falls. Is that right?
Yes.
What kinds of falls are we thinking about in this hypothesis?
I analyzed a fall from standing, a fall from a lower height attempt while she's trying to attempt to get up the first time, and a fall from, say, knee height, if she's trying to get the rake out.
Okay, so she falls onto the rake, ABC, tries to like roll over to get up because she can't sit up and stand up because the handle's in the way. So she has to like roll over. She tries to so then she kind of falls back on it again, slides it, trying to get it out, falls back on it after it slides down, hits D. Then she's able to roll over, get to her knees, and then falls over on it again for E and F, which reorients the angle for E and F.
You were here for Dr. Cruz's testimony that she did not believe that a fall could be enough to cause these kinds of injuries. Did you hear that testimony?
Yes.
From a magnitude perspective, you know, whether the fall from standing, a fall from kneeling could cause these injuries, what is your conclusion as a biomechanical engineer?
That there is sufficient amount of force.
And how do you make that determination?
Using engineering and laws of physics.
And what?
So if she falls back on it though for E and F at a different trajectory, she still has to get back up again because she's found on her hands and knees. So she still has to, she's still having to try to get up. So she again can get to her knees after falling on it again, and then gets to her hands and knees to try to get to the door, and then collapses.
But can you tell, did you have to perform calculations to figure that out?
Yes.
So tell us what you did to make that determination.
So the fall height.
Right. But then she has to fall again. She could have hit it on the wall. Yeah, but she still has to fall again back to her knees. For sure. That makes sense. That makes sense. Okay.
Calculating a fall.
Can you tell, did you have to perform calculations to figure that out?
Yes.
So tell us what you did to make that determination.
So the fall height, calculating a fall height from standing height, you consider conservation of energy principles. So the gravitational potential energy has to equal the kinetic energy. So the law of conservation of energy states that energy cannot be created or destroyed. It can only be transferred from one form to another. So at the height of the fall, that is the potential energy. And as she's falling, you can calculate the kinetic energy using rotational energy combined with linear energy. Once you have that, you can isolate for the velocity, and then estimating a stopping distance, you can calculate an impact force.
And to make those determinations about what those different factors were that go into this consideration, were you relying on principles of engineering, of biomechanical engineering in your field?
Principles of fundamental engineering and science, yes.
All right, and so for the fall from the standing height first, would the force have been of a great enough magnitude to allow Ms. Mullis to be impaled on this rake?
Yes.
And what about from the lower height that you described, from being on her knees?
From you mean the first time she tries to roll over, or which one?
So in the hypothesis you've described, the first time that Ms. Mullis would have fallen on the rake in this hypothesis, she's falling from a standing height, is that right?
Yes.
And for a later fall, I think as you described, she would be falling from a lower height, is that right?
Yes.
And so what about from that lower height? When you did this calculation about the magnitude of the force, would there have been enough force generated in this hypothesis to have caused these injuries in the way that you've described?
Yes.
During your investigation, did you come across any physical evidence that did not fit?
Did I say that unmuted? I don't even know if I said that unmuted. Did I say that? Did I unmute to say that? Or did I just say it? Oh, Jesus. I quit.
with this hypothesis of Ms. Mullis falling onto the rake in the way that you've described?
No, every single piece of physical evidence supported this hypothesis.
Okay, so I answered woman's question that she was about 160 pounds at 5'1". And then I looked back at my computer and I'm like, I think I'm fucking muted. Did I mute after I said it? So dumb.
Just one moment, Your Honor.
I'm talking to myself. Don't worry about me. So silly. Just talk to myself.
In the hypothesis that you've described that you couldn't disprove, you described the rake times that caused wound A and B, which I think your testimony was came first. In this hypothesis would have stayed in Ms. Mullis's body as she tried to get up. Is that right?
Yeah, so A, B, and C happened first, and A and B stay within her body.
All right. And taking that factor into account, that's the hypothesis that's how, testing the hypothesis of how this has occurred, you were able to determine in that scenario that there was enough force to have caused first the fall from a greater height and then the falls that you described that would have been from a lower height.
Yes.
Now, you heard Dr. Cruz's testimony earlier this week that she did not perform any experiments in reaching her conclusion that a fall would not have made these injuries possible. Did you hear that testimony?
Yes.
Have you conducted an analysis that allows you to reach the opinion that that hypothesis can't be disproven?
I've done an investigation that not only can't disprove it, but actually proves it.
And have you worked with forensic pathologists in conducting biomechanical evaluations in other cases?
Oh, yes, for sure.
The hypothesis that you've testified that you can't disprove, is that hypothesis unlikely from a biomechanical or a biomedical perspective?
No, it's completely feasible. We've analyzed all the work that went into this investigation to consider all the physical evidence, including the diagnosed wounds externally and internally, the measurements and dimensions and geometry, and again, intrinsic properties of the rake. Everything fits. So not only does the magnitude match, the mechanism matches. It all matches.
Just one moment, Your Honor.
It's not far-fetched at all.
I'm sorry, one moment. Just two other questions, Dr. Nye. Is there anything in the opinions that you've given here yesterday and today in your testimony that is based on new science that's been developed since 2019?
No.
And are these opinions that you or someone else in the biomechanical field could have offered back in 2019 based on the state of the science then?
Yes.
All right. I have no other questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Dr. Nye.
Good afternoon, Mr. Duden.
How are you doing?
I'm well, and I hope you are well too.
I am, thank you. I want to start by talking a little bit about your background in biomechanics. Certainly, your resume speaks to that, but is it correct to say that you graduated with your PhD in mechanical engineering?
Biomedical, bioengineering, essentially.
And when was that again?
2010.
And since that time, your primary focus, as you testified to yesterday and reflected in your CV, has focused on lower extremity injuries, right? And ocular, I believe.
Since that time, no. That's when I graduated. However, I've been a forensic biomechanical engineer for 15 years.
Oh, I'm sorry, about your publications specifically and the research that you've conducted, has that predominantly focused on lower extremities, upper extremities, joints such as the knees? I believe you testified to yesterday.
Yes, my publications are focused on that, but I've worked in multiple areas.
Based upon a review of your most recent testimony offered in either a deposition or trial format, is this your first criminal case that you've consulted on specifically?
No.
Is it the only criminal case that's noted on the documentation of your trial testimony and depositions that was provided to Mr. Mullis' counsel?
I am not sure. The testimony list I have is for the last 4 years, but I don't really recall it.
Where have you testified for a criminal case?
I have not testified in a criminal case, but I've worked on criminal cases, multiple.
through a consultation format. Is that fair?
It starts out as consultation, but they don't, we talked yesterday, if I don't have an opinion that supports their case, I don't testify typically.
So when you first came into this case, it was to review Dr. Bowley's report, right?
Oh, Bally.
I was
I
a
keep
reviewer
saying
for Dr.
Bully.
Mullis.
In that sense, you simply reviewed her report and then double checked it, in your opinion. Is that fair?
I think I work alongside, I basically listened to her test or her investigation along the way to make sure that she was following the scientific method and applying the laws of engineering and physics appropriately.
So your own investigation came after, however, correct?
That is correct.
And so as it relates to your investigation and your biomedical evaluation, was that first in September of 2023 or June and July of 2023, I believe?
I don't remember timing, I'm sorry.
Okay. When you undertook your investigation, you visited the farm, fair?
I visited the farm.
How wide is the space of the red shed where the incident occurred?
Based on the police documentation, the pathway when you enter the door to the totes was about 2 feet. And then when you walk along, you turn 90 degrees and you enter the pathway where the augers and the pet carrier were, and that was noted to be about 3 to 3.5 feet.
Did you take your own measurements when conducting your investigation?
No.
So no supplemental measurements were taken of the space in question?
No, from what I understand, they had taken, since the incident, it's an active farm, so they had taken things out and put it back in. So I had the documentation right after the incident from the police department.
So in that 2 feet of space, give or take for the walkway, where was the rake?
So the 2 feet was the walkway where she's found by the door. The space between the pet carrier and that space is about 3 to 3.5 feet, but there were 2 augers there.
So where was the rake when she was impaled? That's my question.
On the floor, in the area of the pet carrier is what I believe.
Okay, and where's that documented? Do you recall?
It's not documented there, but that's where the rake was found. I have no other documentation that indicates that the incident happened elsewhere.
Well, to be fair, the rake was found in her back, right?
Well, the rake was found in her back, but the photos have the rake on the ground in the shed.
So the location of where you believe she first became impaled in the rake with the corn rake was back by the pet carrier. Is that fair?
Based on the information, again, that doesn't really matter to me, but that would make sense.
Well, I'm trying to gauge it from a space perspective. Is it fair to say that your report does not outright include the calculations for force or magnitude as it relates to the injuries in question?
No, they do.
Your report details the force and magnitude measurements?
The actual dated report? No. I don't know, actually.
I believe it's in front of you.
Okay.
You can take a look as well.
Thank you. It's hard to remember because I have my notes file.
Oh shit, postpone. I mean, that sucks.
You're correct. I don't actually have the numbers in there. I just have the conclusion that it generates more than sufficient impact force.
But you're not able to know from reading your report, for instance, as to what amount of force was generated based upon your hypothesis, right?
The exact number?
Correct. Looking to your report, do you still have your second report in front of you?
Yes.
Looking to, I believe, the first and second page specifically of your report. Let me know when you're there.
I'm here.
I believe that, directing your attention to page 1, your stated purpose of the letter is to provide your professional opinions based on your biomechanical investigation of an incident, and specifically as to the purpose of your investigation was to determine whether these diagnosed injuries were caused by an accidental fall on the corn rake or the rake being intentionally swung multiple times into her body. Did I read that right?
Yes.
So your evaluation was specifically to look at whether or not these injuries correlated or could have been caused by a fall. Fair?
My evaluation, that was part of my hypothesis, yes.
Nowhere else in your report do you detail any secondary hypothesis, though, correct?
Well, the secondary here is the swinging.
So, fair. And taking that into account, the evaluation looked at falling onto the corn rake, right?
Falling onto the corn rake, correct.
That's one. And the second one is whether or not it was swung into her multiple times. Fair?
Fair.
You do not detail any other working hypothesis as it relates to whether or not it was pressed into her body, right?
In my report, no.
Nor do you actually mention in your report as to whether it could have been kicked or otherwise thrust, struck, what have you, into her body either, correct?
You're correct.
In looking to the actual data information you provided, I believe your evaluation looked only again at a fall from standing or knee height, falling onto the rake, or swinging it, correct?
When you say my evaluation, do you mean my notes?
I believe it's in your notes section. and I'm looking specifically at your numbered paragraphs 1 through 3.
Yes.
And so those only evaluate from a swinging or a falling standard, correct?
And not technically, because I provide my references, which give the information that you can compare the numbers to.
Well, you've never filed a supplemental report as to the information as to whether or not it was kicked into or back, correct?
I did not write a report about kicking.
And so when was the first time you evaluated it from that perspective?
From the kicking part?
Yes.
I don't remember.
Well, I believe the first time it was mentioned here during testimony was yesterday, which you were in the room for, correct?
Well, Dr. Cruz had mentioned it in her deposition.
As to whether or not it was being pushed or kicked into her in her testimony on Monday. That's your statement?
Her testimony in the October 2023 deposition.
Was evaluated from a kick or push?
She had said she didn't know if the tines were entered into her body one by one, if they were pushed or kicked.
And to be fair, your report doesn't detail it from that perspective either, right?
My report does not discuss kicking.
And nor do your notes that were included with that report actually reference it from that perspective either, true?
For kicking, I mean, again, that's a trajectory standpoint. So if you talk about trajectory, then it doesn't specifically say kicking, no.
So there's nothing or no indication to believe that you had evaluated it from that perspective based upon your notes, correct?
I mean, I know that it's there.
But there's nothing based upon your notes provided or your reports that would detail that, correct?
Yeah, nothing in there says kicking.
Looking at it now, how much magnitude would, how much force would be necessary to penetrate the codes in question from a forced push?
It's in here within the references that I provide. So it's 600 newtons, which equals to 138 pounds.
Where's that in your notes?
It's in the references that I give.
Could you point me to a specific place, please, Dr. Knight?
God, he's so snooty.
Your Honor, I don't want to interrupt the witness's testimony, but just because we want to make a record of what this is referencing, I think applicant intends to offer this as Exhibit 976, the document that the witness is looking at. We do just want to make a record of what the witness is actually seeing, since it's this other document.
976.
Yes, Your Honor, and we'll file a copy with the EDMS.
Mr. Duden, did you have any objection to that plan?
I have an objection to admitting the entirety of what would be admitted as 976, Your Honor, as it contains hearsay from other reports and would constitute an evaluated process. As for an improper evaluation, as for the actual calculations or page reference that we've spoken about so far, I have no issue, Your Honor.
All right, well,
He's out of his
maybe on the
lane.
next break, we can talk about what exactly 976 would constitute, see if you can come to an agreement on that. If not, we'll go from there, but I'll hold off on admitting that for now. We'll circle back. I think there was a question pending for Dr. Nye. Do you remember?
Yes.
Okay, you may go ahead and answer.
Sure. It's reference 5, Nolan, the first Nolan.
Of your supplemental notes or of your report?
Of my notes. The last page, I have my references listed. And number 5, the reference number 5 gives you the max push force.
For stabbing attacks, correct?
Well, if you read the paper, it includes pushing.
Well, I'm just looking at it. It's forces generated in stabbing attacks is the one you're referencing, correct?
Oh, do you want the title? Forces required for a knife to penetrate, forces generated in stabbing attacks, an evaluation of the utility of mild, moderate, and severe scale.
Where would your notes indicate specifically other than a citation to an article on stabbing?
Well, if you go to the article and you get the value that's listed there, they basically compare stabbing to blunt activities,
But that's not included.
double hand pushing, and then you compare it to the calculations that I provide.
It's not included in your calculations though, correct?
It's not a calculation, it's the number that's listed in the reference.
It's not noted as a number or otherwise in your actual notes or application of this case, correct?
No, the reference is noted.
And I believe you testified yesterday, you disagree with the category to say you would believe that this isn't a stabbing case, correct?
This is not, she was not stabbed. Does not generate sufficient force.
So there is no way to know based upon that citation alone, in your reports, for instance, that would be the force required to penetrate the skin here, correct?
Objection, Your Honor.
What's
There's
your
no way
relevance?
to know the force required to.
Yeah, there was an objection. The objection's overruled. The witness can continue to answer.
I'm sorry, can I get that question again, please?
Sure.
Now she's getting irritated
Nowhere
with
in your
him.
report is that mentioned from a numerical perspective, right?
It's just listed in the reference.
And nowhere in your application of actual numerical values, notes, calculations, et cetera, is it noted either, right?
No, that number's in the reference, and it's not a calculation, it's a measured empirical number that you take and you compare it to the calculations that I did.
Well, let's
It's a
talk about
known-
you did not do an accident reconstruction
It's
or
a
an incident.
known figure. It's a known figure in her field, and she cites where the known figure is from. So he's arguing. His point is moot, in my opinion, because he's just arguing about what's in her filing. Which, what's the relevance of this?
Reconstruction in this case, did you?
I absolutely did.
Where is that specifically noted other than viewing the scene?
So the entire process of the investigation is an incident reconstruction.
Well, what I see is we've talked about it. You have two hypotheses, fair?
The two hypotheses I discussed in my report.
And as is common in your publication history, which I've reviewed too, you note limitations of the work and research you provide, right?
Specifically with regard to what?
When you are conducting research or experiments according to the guidelines of technical papers or research in your discipline, you are to note the limitations of what you can identify as a causal factor. True?
I think you need to be a little more specific for me, please.
Sure. I'll give you an example, perhaps. I believe you did research as it related to wear and tear of knee joints, correct?
That's not exactly, I think you need to be a little bit more specific or accurate. I'm not quite sure what you mean.
Is it part of the scientific process to note the limitations of what you are testing?
Yes, that's why I do conservative calculations.
That is not noted in your report either, though, is it?
It is. If you actually look at the calculations, you'll note that it's conservative.
For those that are just reading your report, Dr. Nye, it would not be known, though, would it? On what grounds, Your Honor?
As to who would read it, it depends on who the person is that's asking her to speculate on the knowledge of a reader.
It's filed in a legal proceeding, Your Honor.
Overruled. The witness can answer if she's able.
Oh, he's so
I mean,
snooty.
everybody who knew basic physics would know.
Oh,
About your noted limitations as it applies to this case.
About my calculations being conservative, yes.
But that is, as I've said and asked, not noted in your report specifically, is it?
Oh, that's my standard practice to conduct conservative calculations. I didn't write in here the word conservative.
Well, I appreciate what your standard practice is, but what I'm noting is that in your report, we wouldn't know that, would we, Dr. Nye?
I believe that you would if you look at the numbers and the calculations.
Which are not present in your physical report, are they?
They're not in my dated report.
The study of biomechanics is, for injury biomechanics, is the study of the failure of biological systems. Is that fair?
Yes, biological material.
And biological material in this case would be the body caused by the corn rake penetration, correct?
So tissues, yeah, we talked yesterday. Injury is defined as a failure of biological tissue.
And I believe as you described yesterday, your opinion here is that the tissues failed by compression due to puncturing or the penetration wounds caused by the corn rake?
Tensile overload.
And tensile overload would be the compression of the skin at odds with the corn rake, fair?
So due to the blunt object, when you compress the skin, it will deform with the object, and then it will, because of tensile loading, and then will start to tear. And that is why the appearance of blunt force injuries, as Dr. Hammers described, have that bruising and tearing rather than a sharp force injury.
Well, regardless of blunt force, sharp force injuries, there's no dispute that that corn rake caused the injuries on Ms. Mullis' back, correct?
Correct.
And that's in alignment with the medical diagnosis, as you noted too, correct?
Yes.
Because you are not able to diagnose the injury itself, fair?
I do not diagnose the injuries, that's correct.
Nor do you diagnose or note the treated injury patterns as it relates to a medical conclusion, correct?
I do not treat injuries, that is correct.
So the pathological diagnosis here was not being made by you, fair?
Right, I don't diagnose and treat, I'm not a medical doctor.
So your conclusion was tensile overload from penetration with a blunt object, correct?
Yes, blunt penetrating force.
Going through this, you conducted no experiments using the clothing or like clothing that was found on Ms. Mullis' body, correct?
What do you mean by experiments?
You at no point evaluated what additional force would be necessary to puncture the specific clothing on Ms. Mullis' body, right?
I did.
You evaluated the specific requirements added on from the 3 layers of clothing specifically related to her in that specific case.
So the types of clothing that she had on.
In a general sense, right?
The materials. I considered the materials those types of clothing would be made of.
So in a general sense, you applied the research as it relates to the layers of clothing.
Well, if you look at the tags of the clothing, they give the material properties, what they're made of. So denim, polyester, cotton. So the tags of the clothing indicated that.
How long is the rake?
37 inches long.
And that's noted in your report that was filed? Well, rephrase, that's not noted in the report as filed, correct?
I don't know. It might be. I'm not sure.
Feel free to take a gander through it and let me know when you've viewed it.
Sure.
Oh, really?
Yeah, I don't think I wrote the 37 inches long in the report.
And did you document the length of the tines in your report?
Would that be the same question if I wrote it in the report?
Did you note in the report the length of the tines specifically?
The length of the tines? No.
Or the gap spaces and angles of the tines at issue?
I did not put the specifics of the rake in the letter here, this letter report.
Because none of the calculations or information is documented in your written report, right?
None of the calculations?
Correct.
So just the conclusions of the calculations.
And your conclusion is that it would be impossible to cause the injuries at the hand of another in this case?
So to a reasonable degree of biomechanical certainty, more likely than not, it is unlikely.
Well, you say that with certainty there, that you, correct, as to conclusion number 1 on page 5, for instance, you decide certainly that no one swung the corn rake into Miss Mullis's body, right?
Yes, to a reasonable degree of mechanical certainty.
And I believe yesterday you testified that it was a swinging motion specifically, but then came back today and said you had these other hypotheses, fair?
Objection.
What?
Based on what, Your Honor?
That misstates your testimony, Your Honor.
Kelly, can you read me the question?
Judge, see, that's the problem here. Is the judge is irritated with him. She knows exactly what he's doing, and she's half paying attention. This is the same attitude that she had during Hemisath with Todd's attorneys. She's trying to get them to talk about what's relevant for her to make a decision here, and they want to argue like they're in a criminal trial in front of a jury. And she's like, I don't need all of that. I just need you to tell me the bottom line here, which is obviously a problem for Mr. Comover, because he wants all the numbers, even if they're just standardized numbers or numbers from the actual case file. He wants to know the math.
And I believe yesterday you testified that it was a swinging motion specifically, but then came back today and said you had these other hypotheses fair.
Mr. Duden, you just maybe want to rephrase your question. I'm not sure that I even completely understand it in the way in which it was asked.
Yeah, he does.
Sure. I have down in yesterday that you had said it would be impossible to swing the corn rake into her body, correct?
I don't say impossible. My standard is unlikely.
So it is unlikely that it was swung into her body.
Right. So to a reasonable degree of biomechanical certainty, then it would be impossible.
And yesterday you said it's not an overhead swing, right?
Correct.
Or a lateral swing, fair?
Correct. And I said that today too.
And based on my analysis, or at least where my notes cut off, right? Your first mention of kicking, pushing, or otherwise was said today, fair?
I answer the questions that are asked to me. Those questions weren't asked to me yesterday.
Well, it's not noted in your report, is it?
We talked about kicking is not noted in my report.
And it wasn't mentioned specifically yesterday, as you implicitly agree?
I'm here to answer questions. I wasn't asked yesterday.
So that's correct, right? That you were not asked specifically about anything other than swinging the rake yesterday.
Objection, Your Honor.
I believe my, oh, sorry.
This question has been asked and answered, and the record is the record on this issue.
Overruled. The witness can answer if she's able.
I believe my testimony was continuing because it was the end of the day, so my testimony wasn't done yesterday.
He's trying to say that they talked to her and told her to do
You
that.
mentioned that there would be not enough force to push into the body because the literature supports this conclusion. That's what you said today, yes?
Yes, the literature indicates a maximum two-handed push force for males.
And by the literature specifically, you're only referencing that one citation that doesn't reference it outright?
It does reference it. If you
Well, we wouldn't know, right? You would agree that it wouldn't be noted in your calculations. Again, we've talked about this part already.
Well, I listed in my report, It's provided in my report, in my notes.
Permission to work with one of the demonstrative exhibits that were previously used, Your Honor?
Certainly, I don't have access to those though, so
We'll pull up whatever.
sure.
Well, I think I don't know if you needed to switch over that cords. That was mostly.
You have access to them?
Yes, Your Honor.
Great, right. Whoever has the remote might need to turn the TV on for us though.
You have your own. You have your own, right?
Oh, we have a cord.
Yeah, you have your own.
Is that you guys? All right, perfect.
So just a heads up, I'm gonna have to stop in about 10 minutes. So we'll get to wherever we can in a good stopping point and go from there.
To the screen in front of you, showing you what's labeled as demonstrative exhibit J, I believe. This is the demonstrative you worked with previously with Ms. Thompson, correct?
I developed this.
Mostly my question is, this is just the same image that was used when you were working and speaking with Ms. Thompson, right?
Oh, sorry, I misunderstood. Thank you. It is.
So you're familiar with this because, as you said, you created it, fair?
Yes.
This is what you stated on, I believe, your direct examination was the likely scenario of the initial impact, or the initial time impact. Is that fair?
Well, it's a two-dimensional, as I said before, so it doesn't show the 3 dimensions.
But I believe, as you stated, this would speak to the trajectories at issue, correct?
Yes, for A, B, C, and D.
And this is, as you stated, would be the first injury. I believe you called them wound patterns. Is that fair? I don't want to misquote you on that one. First set of puncture wounds that occurred during this incident, correct?
So A, B, and C occur first.
So looking at this, this would be the initial impact for the through and through injury, the one that resulted in the puncture that came out this front side of her chest, right?
Again, this is a two-dimensional profile view of a static torso with no head, no arms, no legs. So it can hyperextend, but yes.
Permission to approach, Your Honor?
May.
I'm going to show you what's previously been marked as State's Exhibit D in this case. Here you go, Dr. Knight.
Thank you.
What is this? A picture of?
This is a picture of a gel torso.
And are you familiar with this image of a gel torso?
Yes.
You took this picture, correct?
Yes.
And it was during your research and experiments as it related to this case, true?
No, my research and experiments and testing and my opinions had already been formulated when I took this picture.
These were subsequent experiments undertaken for purposes of this case, true?
It was not an experiment. I already had my opinions.
So this is you working with the gel torso, correct?
Yes,
And you recognize it because, is that your hand in the image?
that is correct.
And you took the photograph?
Yes,
And it's a fair and accurate representation of your work with the gel torso as it relates to this case, fair?
yes.
Your Honor, I would move to admit State's Exhibit D.
Letter D,
D, yes.
isn't that in already?
I believe it was not stipulated to its admission previously.
Okay.
D and E remain pending.
Any objection to Exhibit D?
You gonna show us?
For, in terms of authentication and foundation, no, I think it depends on the purpose for which it's being offered, which I mean, we would reserve a right to argue its relevance, but in terms of, I believe that the state has authenticated it and laid the foundation in the way that, the way that the state just described it.
Okay, D is admitted.
This, permission to publish, Your Honor.
Yes.
Thank you. So this is looking at a copy of State's Exhibit D, which was just
Hey, Chelsea.
admitted. This is the gel torso work that you're doing,
Yes,
and that's for this case specifically.
it was for this case, yes.
And that relates to a female gel torso, is that fair?
I just wanted to look at it.
Attempted model of a female torso, yes.
And the image shows that it's being impaled by a model corn rake, is that fair?
A purchased corn rake, yes.
And that corn rake was used to be of similar shape or spacing of the tines as it relates to the one at issue in this case?
Yes,
So when the impaled wound trajectory is done on the gel torso here, that's to mirror the initial strike or the initial fall, as you would say, for Ms. Mullis?
yes, it was to try and replicate or demonstrate here wound A.
And it was wound A, if you recall, the one that came out the other side of her chest?
Yes,
Your report nor any of your data collection references her range of motion, though, correct?
her range of motion?
Correct.
No,
It doesn't factor in as more of a dynamic variable, whether or not, I guess, the range of motion of her shoulders or arms, fair?
does not talk about what her range of motion is.
In fact, your report doesn't evaluate what would be necessary or how she would be able to remove the core and rake at issue here by reaching behind her. Is that correct?
So you're just grabbing the rake. You're not trying to grab the tines. But I don't.
So in the theory in question here, your posited way that this occurred, Ms. Mullis reached behind her and removed the rake. Is that correct?
She did not remove the entire rake, no.
But she was able to generate enough leverage or force to remove part of the rake. Is that fair?
That's what happens when you grab the rake handle, which is essentially right at her buttocks. So just reaching, touching, even scratching your hip.
After it had gone through her full chest cavity.
Yes, that's I showed you in that previous diagram.
But you didn't evaluate her range of motion specifically, correct?
Your Honor, I don't know that the witness had finished her answer.
There's a question pending. The witness can answer that. Please, counsel, just let's try to let the witness finish her answer before you ask your next question.
Is that okay?
Sure.
Okay. So as that diagram previously showed you, when the rakes are lined up with the horizontal trajectories, the rake handle essentially is against her body or against her buttocks. So essentially you're just kind of scratching. You can reach back and grab it, it's touching you. And pulling it in that manner, the second diagram where you grab the rake or reoriented, that essentially, because the rake is stiff, it creates a leverage to pull out one of the tines. And the tine that it pulls out is not deep, relatively speaking. That's why A and B stay in.
Is range of motion an important factor as it relates to biomechanics?
It depends. If I'm talking about a gymnast and someone doing, the splits or something, but this is not what we're talking about here.
Is it a relevant human factor as it relates to the evaluation as per the sources you've included in your report?
It wasn't something that was questioned because I don't have information that she worked on. She's a manual laborer. She was doing manual labor that day. She can reach down and tie her shoes. So
I apologize. And I understand that, but you didn't evaluate from whether or from what perspective the ability to reach behind her or her range of motion to be able to reach or contract, correct?
You want to try to figure out Amy Mullis, who's dead, and you're investigating the biomechanical of her murder or her death, and you want her to figure out what Amy Mullis's range of motion was in 2018. Okay, so I'm gonna stop it here. I'll when we start tomorrow, I'll kind of go back just so we'll have a better feel for exactly where we are. But so an interesting side conversation that's happening kind of in chat is Todd. This is why his appeals have never gone through, is because when Todd testified at the trial, he said she was murdered. The way that it's said is kind of in a context of that's what he was told. So how is he going to say that she wasn't murdered? But his attorney, during opening statements right off the bat, is automatically saying it's a murder. It's a murder. It's a horrendous murder. It's a terrible murder. It's totally bad. It's a really, really bad murder. And so he ends up when he's testifying essentially saying, yeah, she's murdered, because that's what everybody's saying. Everybody is saying that she's murdered. And Paul, correct me if I'm wrong, but during that trial, aren't there conversations that he's having with his family where he's complaining that his attorney is doing all of this and kind of putting him in this situation? I don't want to get the timing of those calls wrong. So I just want to see, but I'm almost positive his sister testifies later about it. Okay. But they won't let those recordings in, I don't believe. Yes, he was complaining to Lynn. Yeah. So it is a tough situation. It's a tough situation, and to his attorneys. Okay. Like, hey, this is not what I want you to do. Okay. So I'm going to wrap it up. I got to go pick up, I got all 3 kids to pick up today. So I'm contemplating, depending if I can get the shit done that I need to get done this afternoon, of doing a live tonight on I have some stuff to go over with Delphi and some stuff to go over with Idaho. So I don't know if I have time. I may do a later live tonight on one of those two cases. If I don't get my shit done, then I won't be able to. But I will be back tomorrow either way, same time, same place, and we'll pick up right here where we left off, and hopefully be able to get through the rest of this. I mean, this day's almost over, and then we should be able to get into the next day. So other than that, go. If I don't see you live tonight, then I will. I know I need a Delphi. I've got tomorrow is another read hearing. I know I got to do a whole read thing too. I know there's too much. It's too much to do. Too much to do. All right, well, go enjoy the rest of your Wednesday. I might see you guys tonight. Of course, I'll post it if I do, or you guys make sure you have your notifications. Delphi has a lot of useless drama. That's true too. But I got some stuff I actually want to talk about with the case. I don't know. We'll see. I'm avoiding Delphi like the plague. Well, I also need to do Idaho. So, like I said, if I have time, I'm going to do one tonight because this would probably be the best night to do it. But I have some shit I have to get done in order to be able to do that, because the stuff I'm not getting done during the day now has to get done at night. So either way, I will, no matter what, I'll see you guys here tomorrow morning, and we'll go from here for Todd Mullis. And then hopefully I get some more responses to the Foya requests, and we'll see what we get. All right, you guys, go enjoy your Wednesday. I will see you guys later. Bye.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. Head into the unknown.